To start with a few words, I just want to point out that I have written 4 memos to the planning board since the last hearing, and I know you don't want me to go through them in painstaking detail. Shall I, however, go through them in a summary fashion? Would you want me to wait?
If you wish to, Mary,
start with
yes.
that?
If you can condense them tight.
Okay. Or at least to just point out what information I've given to the planning board. And I'm going to start with the most recent one because I think it covers a number of issues that we've talked about. I've certainly summarized this proposal to the board a number of times. I've tried to highlight what I think are the key issues in this application. I guess I'll just repeat to start out with that this is an application for an open space development permit under Section 6, subsection M of the Milton zoning bylaw. This is a special permit, and it allows a type of development that normally is not permitted under our zoning bylaws. It allows a development, in fact, it requires that the division of land be on a major private driveway. It requires that every lot be at least 4 acres, and the largest acreage we normally have in our zoning bylaws lot requirement. It requires that there be at least 10 acres of a long-term planning issue, that they consider, first of all, whether the purposes of this bylaw, which are to protect open space, to create additional open space more than you would normally have in a subdivision or other type of division of land, and also to try to protect some of the unique neighborhood character that we have in Milton. And those are the 2 objectives expressed in the first paragraph of the bylaw. And these are the things that the planning board is to consider in deciding whether it's appropriate. First of all, does the application fulfill the requirements of the bylaw? And is it an appropriate part of the type of planning that a planning board does to grant the permit and have the development occur in the way that it's proposed? As part of that long-term planning, the planning board is also supposed to look at how likely it is that the development will be completed. And I just point out that in this case, the lots have actually been marketed. There are buyers for the lots. There's a high likelihood that it will be completed if a permit is approved. The most recent request I've received from the planning board was to respond for them in writing to an email that was distributed to Hillside Street Neighborhood Association. And it happens that the email covers, a number of the issues that have come up repeatedly and which have been questioned and are well worth addressing again. And I've already sent copies of this to the planning board, so you've had a chance to look at it. I'm just going to briefly go through the questions that were asked. The memo does begin with a statement that our proposal has been to widen and improve the existing driveway and extend its length. We have not proposed, as of tonight, widening the driveway. We propose keeping it at 12 feet, although we've pointed out numerous times that it's responsibility of the planning board to look at the driveway dimensions and decide what they feel is necessary in this case for safety and access, proper access, because the way into the lots has to be accessible. First question was, again, about whether we have 10 acres of buildable land on this site. The way we approached analyzing whether the land was buildable or not is the same way it's been approached in the 2 previous permits that have been granted by the board. We first went to the Conservation Commission and we asked them we went through a long process of looking at the wetlands delineation and walking the site with them and returning several times. And finally in January, they voted the wetlands delineation for the property. So on the plan, those areas designated as wetlands are considered to be not buildable. In addition to that, it happens that the other property is upland in these other applications, the land that is not wetlands but is upland has been treated as buildable land. The question asked by the neighborhood association is, why is it that you are counting as buildable land, for example, the 25-foot wetland setback? And the reason for that is pretty simple. The setback is not a non-buildable zone. It's a zone in which building can occur if the Conservation Commission wants to give permission for it, and is usually accompanied by a number of special conditions. But it was never intended when the wetlands regulations, Milton's wetland regulations, were developed, that be a no-build zone. It does not mean that the land is not buildable. It just means it's land close to the wetlands. In some towns, or under the state DEP, you can build right up to the wetlands, the edge of the wetlands. The other areas that were questioned were the 30-foot setback for buildings and the setback from driveways and the driveway itself. Again, the first thing you do is to take the site as an entirety. It's total acreage, to do the wetlands delineation and figure out what's wetland and what's upland. The other dimensions that are being talked about here, the setbacks for distance for buildings from the edge of the lot and so forth, those aren't determined until you divide the parcel up into lots. The calculation for buildable land is done for the entire site. It's not a lot-by-lot calculation. And what that tells you is that you don't take into account the setbacks. The setbacks, again, do not designate property that land that's physically cannot be built upon. It's a setback that's established by the zoning for each individual lot. It's a distance that you have to stay back from the lot edge, with your house. And the same sort of analysis applies to the issue of the driveway area. The driveway, the major driveway, which is a requirement of an open space development, must be created and it's created out of the overall acreage that's available for the site. So when you're calculating the 10 acres, you take the total acreage, you look at the upland, you look at the wetland, and you don't take into account those other setback requirements. That's the way the planning board's done it for the other two permits it's issued. And I think it makes sense and it's logical. That's the rationale behind that calculation. Second question is the driveway design safe? Does it allow access by emergency vehicles? What we did to try to, first of all, the proposal that we have before you right now, the 12 feet, that was generated by comments from neighbors that they wanted the driveway, they wanted the whole area, and from the neighborhood itself, for that matter, the neighborhood association, that they want the neighborhood to look the same. They don't want to see a major change in the appearance, the rural appearance of this area. And an issue for people is the appearance of the driveway. Does it look like a driveway, or does it look like a subdivision road? And we were, originally considering proposing a wider driveway, and we're willing to consider discussing a wider driveway if the planning board feels it's needed for safety. But what we did was, we took the 12-foot width that presently exists. It's variable, it's 11 feet, 12 feet. And in our plan, we put in a 12-foot pavement, proposed pavement. And we brought the fire chief in and walked the entire site, including having him look at the back area that isn't developed. And we asked him a number of questions. First question was, is it safe for a fire truck to access these lots with a 12-foot wide pavement? A fire truck is about 9.5 feet wide. And he looked at the site and the design of the driveway and the width, and he said that it was safe. He said he would want cutouts at certain areas in the driveway so that there would always be an area for someone to pull off in case an emergency vehicle had to get by. And he was willing to show us where he thought cutoffs should be. The second question was, what kind of an entrance does the driveway need to have so that a public safety vehicle can get into this driveway safely and quickly enough in case of an emergency? And his recommendation was that we widen the driveway entrance, just gradually widen it at the very end, because he wanted an angle that was softer, so that if a fire truck were approaching in an emergency situation, it could turn quickly into the driveway. If you have a 90-degree angle, as you do now, it's difficult for a fire truck to turn quickly. It has to slow down in order to make that turn. So he recommended widening the driveway entrance, and the dimensions he recommended are those that you see on the plan that's before you. The third thing he brought to our attention was the fact that this is a 900-foot driveway right now that has no fire hydrants that are working on it beyond Hillside Street. And he said that what you have to do now is you would have to have 2 fire trucks, and you'd have to link together the full length of hose for both trucks in order to reach houses at the end of the driveway. He said that's right at the maximum of what they can possibly do right now as a fire department to provide fire safety, and it is not ideal. And what he recommends is if there are going to be new water lines put in under the driveway, that 2 new fire hydrants be installed, one halfway down and one at the cul-de-sac to serve the houses that would be in the rear, in the undeveloped area. So he made those 3, he made some recommendations for changes. He looked at the driveway width. He thought the width was safe, manageable, and accessible. He didn't even really think that we had to trim branches particularly to allow a truck to get in there, but we reserve judgment on that. I mean, it may be possible that branches do have to be trimmed. That was his judgment. That was quite important to us. And I believe he looked at this before we came to our first hearing with the planning board, and that's why we put the 12-foot width in our application. But that is a decision for the planning board. It's a matter of discretion of the planning board what the dimensions of the major driveway should be. Third question, should the developer be required to submit a full subdivision plan, or does the proposal qualify for one of the exceptions in the bylaw? I wrote a 5 or 6 page memo for the planning board on this subject. So rather than go through it in detail now, I'm going to touch on, just very briefly, on my approach to it. But to say that our conclusion is that no, we do not need to submit to subdivision approval review. These lots do not require subdivision approval. And furthermore, as I've said before, the board has done 2 other permits, open space development permits, and did not subject those applications to subdivision control review. Now, what I did was to go back and analyze the text of the bylaw, which is very important because the bylaw states clearly what its purpose is in its first paragraph. Is to increase open space and protect rural areas. It states very clearly in a later paragraph that every open space development must be on a major private driveway. Driveway being a dead end, not the usual sort of way that we require that lots be on. And by its very definition, that part of the bylaw contradicts the definitions in section 1 of our zoning bylaw that define driveway and define frontage. And there's additional language at the end of subsection M explaining what to do with conflicts in definitions if they arise with the language of subsection M. And basically that language says subsection M prevails if there's a contradiction. Otherwise, all other provisions of the zoning bylaw apply. So what the bylaw does is it allows, or it calls for, frontage to be on a driveway. Before 1958 in Milton, you could have frontage on a driveway or a way that was not a standard way. And the bylaw was changed in 1958. This bylaw was passed in 1982, and it's pretty clear that there were things going on that the planning board was looking at and was concerned about, that they wanted to give some flexibility to themselves and to the town and to neighborhoods to provide for something else other than a straight subdivision in certain situations. And that's what this bylaw is all about. If you say that you have to subject this to the subdivision control rules and regulations, some of those provisions directly contradict what's permitted by this special bylaw. And so you either don't have the bylaw and you go forward with the subdivision control, or the bylaw continues and you read the other parts of the zoning bylaw and the regulations consistently with this bylaw. And I believe that's what would happen if this went to court and it had to be interpreted. I believe every effort would be made to uphold the bylaw, which was passed by town meeting. It's a legislative act, and a great deal of deference is accorded to that type of bylaw. If it can be read consistently, it will be read in such a way that you will still be able to follow the bylaw as a planning board. A lot more detail, I guess, or there's more detail in my memo, but please read it through if you want to take another look at this issue. Question 4 was, does the proposed plan include adequate drainage for the driveway? I think what we expect to do is to have this question addressed before the Conservation Commission, and we expect there will be conditions that the Conservation Commission will impose, and there will be specific, probably drawings and indications of what we have to do to make sure that we've addressed drainage in enough detail and in the way that the Conservation Commission expects us to do. So we expect that that question will be addressed at the Conservation Commission, and we are already scheduling ourselves to go back there to discuss this issue, among others, in the next few weeks if possible. Next question was, would use by 3 more homeowners place an undue burden on the Corlisses and the Jepsons, who are the 2 families who use the driveway for access to their homes? Well, it's our position, it's the applicant's position, that there will be a small increase in traffic. There will be an increase in traffic. There will be 3 homes in the back. But we don't believe it will be a terribly intrusive type of traffic. It will be, at different times of the day. And what we think is probably more important is the fact that the driveway, as a means of access to any new lots in the back of this property, will continue to be available. The driveway is a lot, and it is owned by the owner of the lot to the rear. Ever since Mrs. Safford first subdivided this property, she retained ownership of the driveway. And what she did was she gave a deeded right to use the driveway to each of the abutters as she sold lots along the driveway. So each of those abutters has a property right. It's a right to use the driveway, but the ownership of the driveway, the underlying title of the driveway, was with Mrs. Safford, and then when she sold her remaining land, first to Mr. Campbell, and then Mr. Campbell sold it to Mr. Fandry, that ownership went right along with the property. The ownership of the driveway means that the person who owns the lots, the area in the back, should they choose any form of development, has the opportunity to grant a right to use the driveway to any new lot owners. It doesn't mean that it can be the legal subdivision control access. It doesn't mean the planning board has to, if you want to pursue a subdivision with more lots, it doesn't mean the planning board has to grant the right to the primary frontage to be on that driveway. But that driveway can still be used. So the objective here should be to minimize the number of lots in the rear here. Because if you minimize the number of lots, you will permanently limit the amount of traffic that you can ever expect to have in the future along this driveway. And I think that that's an important objective, and that is one of the reasons that we are here with this application for you today. Because this is one of the other way that you can control what happens on the driveway is to use a special permit like this one, because a special permit can have conditions. And you can condition the use of the driveway. You can require that there be more limitations on the use of the driveway through the special permit than you can today. Today, everyone who's using the driveway, anyone who owns that back lot, if they just want to continue to use it and use it as one means of access to other lots in back there, they don't have to make the pavement 12 feet wide. They can make it 30 feet wide. And everyone who has a right to use the driveway has a right to dig it up and put new utilities under it anyway. So, I think There are benefits associated with doing an open space permit in terms of permanently restricting development in the back of this property and permanently limiting the amount of traffic that can in the future occur on the driveway, putting in new water lines, putting in new utility lines, and all the lines under this driveway are privately owned, would be put in if they had to be put in any other time at the expense of everybody on the driveway who uses them. If you do this open space development, the developer pays for the new lines, and they won't have to be replaced for a long time into the future. Finally, Mr. Mussey referred to the fact that he felt it was the intention, as the writer of the email, of the owner to access the site proposed for development from Ford Ranch Road when he purchased the Ford Ranch Road lot. Well, the person who purchased that lot, Mr. Joseph Andry, has passed away. He passed away 5 years ago. I can't really speak to his intention, but what I can say is that that lot was purchased in 1966, I believe, and since that time, the wetlands, the state wetlands law and the Rivers Act have all come into being. There's been a tremendous change in regulation of wetlands since that time. And what might have been a little easier to do in 1966 is much more difficult to do now. And so, we are mindful of the fact that a Conservation Commission and the state DEP are going to have a lot to say about preferred routes into this lot, and that the fact that the lot on Ford Ranch Road is almost entirely wetlands and has a stream running along one edge are very persuasive facts to tell you that if there's an alternate way to get into the property, DEP will want you to use it. So that certainly is something that has also influenced the choice of application. I think the last question was, how much should the stone wall be widened to allow safe access? I think I covered that already by saying that we took, for guidance on that question, the advice of the fire chief. Because what he said was, the fire truck is a big truck. It has to get in fast when it needs to get to your house. And we thought that whatever he said was needed as an angle of access and a width of access is what we really should be putting in our plan. So in the case of the size of the entrance to the driveway, our application is based on what the fire chief recommended. So that pretty much covers the questions that the Neighborhood Association submitted to us. I have an addition sent to the planning board. I'm not going to go through it, but I just want to point out to you a draft of a utility and access easement and covenant. This would be something that would be required of new lot owners in the back lots. And it explains that the new lot owners would be 100% responsible for the maintenance, plowing, and care of utility lines and so forth for the new part of the driveway, the part beyond the cul-de-sac, and that those same lot owners would be proportionately responsible for the care and maintenance of utility lines, plowing, and so forth for the existing part of the driveway. So there would be additional people to contribute to the cost of plowing, for example, in the wintertime for the front part of the driveway. The back part of the driveway, all of that cost would be assumed by the new lot owners. I've also given the planning board a brief memo because Mr. Whiteside had questioned why it was that we have a driveway located on the side of the lot that's close to the lots on Ford Ranch Road. And went back to Mr. Hamilton and our engineer and asked them again, why is it that you located the road the way you did? And the answer was that they had considered locating it in the middle, and they considered putting it over on the left side. But the reason they put it here is if they move the road over, they have to put a structure. They have to put a home where the road is or closer to where the road is. And because of the topography of the lot, it's higher up over there, and then it dips down towards the adjacent lots on Ford Ranch Road. You want as little visible as possible. So you want to move the structures away from the edge near Ford Ranch Road, and that means putting the roadway over on that side. And all you're going to see with the roadway is occasional lights at night. In the daytime, you're not going to see anything, because it's just going to be a roadway surface. So they felt that this was much preferable, both from the standpoint of existing homeowners on Ford Ranch Road and from the standpoint of new homeowners on these lots, so that they would have greater privacy and Ford Ranch Road would have greater privacy. That's the reason why the driveway is where it is. I've summarized the subdivision control approval issue. I gave you a memo about that. It's 6 pages long. I hope you've looked at it. I can answer questions later if you want. I think I covered some of the questions, most of them that were asked at the last hearing, because I also sent you a memo responding to those. I'm just going to look quickly here. See if there's anything else to cover. I guess the question, I think we're going to be talking about it tonight, so I won't go on and on about it now, but the question of whether we should be providing cost information for a bridge over the stream. The simple answer is we're not applying to build such a bridge. We didn't feel that we should have to do a detailed engineering cost estimate. To do an accurate estimate of the cost, you really do need to spend quite a bit of money. However, since we're going to be discussing it later, maybe I can address my remarks at that time in response to some of the information that's been provided to the board. There are some questions that were asked about shouldn't we have a construction management plan? I do indeed feel the board should talk about construction management if it issues a permit. There should be some criteria that should be included in a construction management plan. I can make suggestions and the board may have more ideas about that, but we don't object to that idea. The issue of unnecessary cutting of vegetation, that's usually addressed in these permits with some kind of language, and we feel that's appropriate. And I think there was a comment made that there will be tremendous inconvenience, noise with this project, and that was a reason not to grant the permit. And I think we all have to recognize that any construction project does bring with it inconvenience, and there can be noise, there can be dirt and all kinds of problems. But all construction projects have those problems. It's not unique to this one. Because this is on a driveway that's shared, however, or is used by at least 2 families for regular access, there should be conditions in the special permit relating to how to make sure that as little intrusion as possible occurs if construction is going to be done. And there are a number of conditions that I can suggest along those lines. So that just briefly goes over some of the material that I've given the board. Even that wasn't very short, and I'm sorry, but those are my comments for the moment.
Okay, ma'am.
Thank you.
And just stay there, please.
Yes.
Are there any questions from the board to Marion?
Not on the most recent information.
I don't know if I formulate this right, if it's a question or just some thoughts that I want to see if you can give me some response to. It would seem that when they wrote this bylaw, they probably pictured there's some significant estates in Milton, and that at some point in time, these estates may break up and happen exactly what's happening here. And it would seem that they may assume, maybe I shouldn't say assume, but it would seem that the thought process would have been that that estate probably was on a public road. And in which case, this private driveway would come in off that public road, and rather than develop a street to develop frontage and everything, it would be a private driveway to maintain the more rural character that the estate had.
Mm-hmm.
But with that thought process that I just went through, that private driveway would be created on that estate, and it would only impact the new construction. This seems to have a little bit of a different character in the fact that it's a private driveway that's created to get to these lots, but it's also an existing private driveway that's now going to impact people that presently live on it. and I don't know if you follow what I'm getting at.
I do follow.
It seems that they plan to break up an estate and, for the lack of, again, better terminology, create a little subdivision out of that estate, but not create a new public road and so on and so forth. But yet it was unique that it was contained in itself. Now, it seems like to do this, you now have to bypass existing situation that may not have been thought through with this bylaw. And with that, I just ask, has that ever been thought of, or?
Well, I've certainly thought about it, and that's one reason I went through all of the planning board minutes from 1980 to the present. And I looked at what notes there were. There weren't a lot of notes from the public hearing about this. But I did find a note, about that issue. It was written by a planning board member, and I can provide it to the planning board. I'll have to go back and get it, and it doesn't have any, what's the import? This is a note written by a planning board member on the margin of a document that was then filed. But it said that this contemplates that this driveway might go by existing homes and around to the back of them, and then that the new lots would be created there. That indicated, just that note, just from that one person, indicated to me that they did think about, or were thinking about this as possibly occurring in situations such as this one, where the driveway would go by homes that were already on a way and then would extend it and create lots in back. Now, that's all I have.
Or could it have possibly meant that this new private driveway was going to bypass homes, not necessarily that used it as access, but just were...
Easily, but either way, it would be near homes, and, I think they were thinking that would be possible, that there would be
knowing that you're
impact.
probably more familiar than I am with this, this bylaw M was used off of Woodlawn Road?
It was used, there's a development that turns off, Woodland Road itself is actually a dead end,
Right.
but it's a long road. It turns off Woodland Road to the right and goes up 2,000 feet, sort of winds around, and it's really, that particular development is very much of an estate with a lot of stone walls.
Yeah, and again, when they took that road off of Woodlawn Road, they created that private driveway that didn't at that point bypass any other homes, the private driveway anyways.
That's right.
Where is the other bylaw M development?
It's on Harlan Street, and it is now owned by the developer who's brought this application.
Okay. Yes,
And
I am familiar with that.
there's a driveway that goes up a hill, there's houses there's a new house to the left, there's an existing house, there was land added to that open space development that has a house on it, that's to the rear of it, so it's kind of complicated, but the planning board perhaps is more familiar with that than I am, but that's the other one.
Tom's property.
Yeah, well, there was a third one that was permitted, but it was never built. This was Tom Flatley applied to build one, and that one would have been accessed by going down his Deerfield Drive, I believe, if I understand this one correctly, and entering at the end of Deerfield Drive, and then extending a new driveway, an additional driveway, and building 2 or 3 lots, I'm not sure what the proposal was, and that sat there for about 15 years, I think, and then finally, I guess the land was bought by someone else, and they ended up building 4 lots and accessing it off on Woody Road.
I am familiar.
So there actually were 3 issues.
Any other questions for Marion at this time? No, thank you, Marion.
Thank you.
Well, yes, I do, just, I apologize for not having been here the last meeting. My wife has been in the hospital, she's still in the hospital. I don't know if this is the time I should mention this, but my only concern of what I see is the width of the proposed driveway. Having had the ambulance come to my house 12 times, and, I mean, it's such a really narrow strip, and now I find out that there's obviously an existing easement by Esther Jepson's house to get to her house. Now, if we want to increase this 12-foot width to something greater, which I want to do, and I'll speak to it when it comes to that point, how do we get them to increase their width, which is 12 feet.
Oh, no, well, actually, the Jepson family, the Corliss
Yeah,
family,
Corliss,
the
right.
McDonough family, and other abutters, they all have a right to use a 30-foot wide right-of-way.
Okay.
There's nothing that has to be changed in
It
that.
just says 12 on the map that I'm looking at.
That's what we're proposing is a pavement width in the major private driveway.
Okay.
And right now, it's very hard packed, very solid, but it's a dirt driveway. We're proposing a 12-foot wide pavement width. The existing 30-foot right-of-way is a utility easement area, but it's also an area that can be used to make the driveway wider. Now, the tightest section, because of
That answered my
okay,
question.
but just
it could be-
to explain, you know, how we've been trying to accommodate what are, you know, somewhat conflicting interests. One is, you know, keeping the driveway looking the way it is. Also accommodating the fact that some of the people have the right to use a driveway, and one family, the McDonoughs, have actually planted a protection screen of, you know, some yews, or I don't know what the bushes are, but they're very tall at this point, in the driveway, pretty far into the driveway. And everybody seems to want to really leave that protection there, and I personally would like to see the McDonoughs be able to continue to have that vegetative screen, because their house was once just a cottage, and it was really close to the right-of-way, fairly close. And so now it's a gorgeous house, and they've improved upon it, and they made a nice back area and landscaped it, and they would like to protect that. And so that's been an issue in terms of, you know, keeping the width narrow, but the safety issue is the paramount issue, and I think you've said that yourself. I mean, it has to be safe and accessible. There is another way to deal with the driveway width just near their house if all the neighbors wanted to do it. They could shift the driveway over slightly, but everybody, the Bresnahans, the McDonoughs, the Foleys, would all have to want to do that, and there'd have to be some transactions of slivers of land. So I believe the primary issue should be safe and convenient access while maintaining an appearance that is as close as possible to the rural appearance that's there now. But safety's paramount. So I'm bringing that up only to say we've really tried to deal with existing conditions and be sensitive to them, and to really protect vegetation. And at the same time, I think everybody would like to feel that it's going to be a safe pathway in, even safer perhaps than it is now, but definitely safe to get into the back houses.
Just one other question. Does that easement include, allow streetlights?
It doesn't say anything about, no, not automatically. I don't think.
Right away are usually allowed?
Well, I looked at the state law saying, what rights do people who have a deeded right-of-way have in the right-of-way? And what the state law says is, you have a right to put your utilities underneath it. So you can run all your utility lines under it. You can dig it up to do that. Any one of those people with the right to use it can do that. They also have an obligation jointly to maintain the right-of-way in whatever way they feel is necessary, and to trim vegetation. It doesn't specifically say that you have a right to put utilities above the ground. I don't know how often that's done on private ways. The solution sometimes, when people don't want, if they're worried about lighting on a way like this, but they want to maintain the driveway appearances, that they will do lights at the entrance to each driveway or something like that, so that it looks like a house light, but it also provides additional lighting.
The only other question, Marion, is, I'm thinking, is plowing. I understand that Esther and Mr. Corliss plow the driveway now. They have some shared
I believe
agreement.
they share the cost of plowing it.
And then the new owners would pick up, or would they contribute to the opening?
They would have to contribute proportionately to the cost of plowing the what I call the existing driveway. They would have to pay 100% for the cost of plowing their end of the driveway, the part starting at the cul-de-sac. So, I mean, you know, it's a sort of a smallish thing, but, you know, if this development goes through, there will be more people contributing to the cost of plowing the driveway, yes.
Thank you. I think
Okay, good. Anybody else? No. Okay, Marion, thank you. Thanks, Bob. We'll now have Mr. Bobrowski come up, please.
Good evening, Mr. Chairman, board members. Mark Bobrowski, for the record. My office is in Concord, and I represent Mr. and Mrs. Corliss. I guess I'd like to make 4 points. We've been going at this since May, and I think I've had a fair audience here, and I've been heard with most of my arguments, but I want to reiterate them and introduce you to Tom Houston, who's a registered professional engineer who I've asked to join me here this evening. First of all, this is a subdivision. There's no escaping that. Your local bylaw interpretation doesn't matter. It's a state law. 81O of the Subdivision Act says you can't divide land into various pieces without going through some form of land division recognized under the Subdivision Control Act. So there's only two. It has to be an approval not required plan, or it has to be a definitive subdivision plan. It doesn't qualify for A&R relief because the road, the private driveway, is not one of the three types mentioned in Section 81L of the statute. That is a public way, or a way shown on a definitive plan, or a way in existence. And it's pretty clear that it's not one of those three things. Now, I'm not suggesting that they can't come back and later get a barrel full of waivers and get an A&R endorsement, but please don't be misled that they don't have to come back and do that. They do have to come back and do that. And when they do, you're going to have to grant waivers specifically for dead-end limitation. You're going to have to grant waivers for pavement width and for right-of-way width. And those are the three that jump out at me. To avoid Section 81O is a cheap and easy lawsuit, so why go there? They cannot carve this up into land lots for sale until they've gone through the formal process required by state law, and no interpretation of the local bylaw can relieve them of that obligation. My second point is that it's an unsafe subdivision, even if you grant those waivers. And I acknowledge that the chief has weighed in here and said that a 1,750-foot dead end can be serviced, but I don't think that that's an AASHTO standard that's recognizable. Tom will tell you that he serves as the planning board consultant in Canton, Norfolk, and in Bellingham, and they would not grant a waiver for a 1,750-foot dead end. It just isn't done commonly, especially on a narrow road. As you yourself pointed out, with 14 ambulance visits, a 12-foot road is hardly serviceable. I don't think widening it to 16 feet is the answer. I say prohibiting it beyond a certain limitation. Your subdivision regs say 650 feet. Give or take would be the right answer. But a waiver more than doubling, almost tripling the length of the dead-end road on such a narrow proposed layout is just inherently unsafe, regardless of the position that it can be serviced. The third point, I think, is perhaps my most important one, and I've made it before. The applicant before you this evening has no as-of-right position. You asked, sir, what the purpose of this bylaw was years ago, and I've written bylaws in 100 cities and towns, so I think I'm probably as well qualified as anybody to talk about these alternative forms of residential development. Yours is admittedly not the usual in that you require 4-acre lots, but alternative open space laws, flexible development laws are generally ones that allow for more sensitive land development. But they always begin with the premise that show us what you can do as of right. If you can do 6 as of right, and you want to do 4 under open space or flexible development, well, that's a good bargain. You could have blown a 30-foot right-of-way in there, or a 30-foot pavement back in there, and 40-foot right-of-way, and put 6 cookie-cutter houses. We'll give you 4 estate lots, and that's a better response. There is no as-of-right position here. Without your special permit, they cannot build anything under this proposal. They have no A&R rights on the driveway, and they have to have a waiver from you on a subdivision. And you don't have to grant a waiver for a 1,750-foot dead-end combination of roads. So it's not like you're getting a bargain here. You're giving away the farm, if you will, in a situation where you don't have to give them anything, and you will be upheld by the court. That's the bottom line here, plain and simple. They don't have any position that they can use as leverage with you. In ignoring that, you're essentially just giving them what they want. I think the bylaw doesn't really address that, and perhaps that's a question for later as to how you can ask an applicant first to demonstrate their as-of-right position, but that's the customary way that these bylaws are designed to work. Show us the money, and then we'll talk about what we'll do in return by way of a bargain. And the trade is usually simple. We'll reduce your road length, we'll reduce your lot requirements, area, frontage, width, setback. In return, you can shorten up your infrastructure costs, and you'll get wonderful estate lots that are back in the woods. Everybody wins. Nobody can see them. It's a win-win proposition. But that only applies if they have an as-of-right position that you don't like, and now you want to horse trade with them to get a better deal out of it. The alternative here, from your perspective, unless you give them a special permit, is that those woods will still be there tomorrow and forever. That's the alternative. Now, the last position I want to make, and I asked Tom to join me tonight, is that they have a real alternative off of Ford Ranch Road. And that they can do under the limited project exception in the state wetlands law. As I indicated either last meeting or a couple of meetings ago, 310 CMR 10.533E is the limited project exception, and it says that a wetlands crossing is permissible where there's no reasonable alternative means of access to the upland area. If the special permit is denied, it will foreclose any argument that there's a reasonable alternative means of access, and it's a readily defensible denial. Tom has looked at the costs associated with bridging the wetlands, and I'd like to have him talk a bit about that now.
Thank you, Mark. Members of the board, good evening. My name is Tom Houston. I'm a professional engineer in the state. By way of background, I am the engineer of record and am responsible for the design of over 500 land development and roadway projects in my capacity as a peer review consultant to boards and commissions in Massachusetts. I have conducted peer reviews of over 400 land development and roadway projects. On behalf of Mr. Corliss, who is an abutter to the project, we developed an order of magnitude cost estimate for a bridge that could be used to span the on-site stream in conjunction with building a common driveway or roadway from Ford Ranch Road into the interior of the project. My understanding was that this project was discussed at prior meetings of the board, and what was discussed was a highway-type bridge that would clear span the stream, and the dimensions discussed were 20 by 30 feet. We did review available cost information from both Mass DOT and the Federal Highway Administration, and in our judgment, the available cost information was not applicable to the scale of a bridge that would be used to span a stream on a private site.
Mr. Chairman, do you have a copy of Tom's report?
I think we do, yes.
Okay, I just want to make sure.
I did bring copies.
That would be helpful. Mine's on my iPad and I can't connect. So the limits of technology.
You can actually have a dozen copies. Thank you.
Thank you.
Yep.
Another one there.
Oh, I'm sorry.
No, we were
I'm
all
all
set.
set. I
Thank
have
you.
one.
Having determined in our judgment that the Mass DOT and FHWA cost information wasn't applicable, we did locate a study that was done in the state of Vermont, and the bridges in that study, I think there are about a dozen of them, were closer in scale to the bridge that would be required here. The bridges had spans of between 50 and 100 feet. They were designed to carry both pedestrian traffic and light trucks. Out of those 12 bridges, we selected 3 bridges that were being constructed in new locations, i.e. new bridge abutments and new bridge decks. As the independent variable, we chose the area of the bridge decks. And for the 3 bridges that we evaluated, the average cost for a square foot of the bridge deck came out to $235. We increased that cost by 15%, which would account for the engineering fee required to design the bridge. And we increased that cost by yet an additional 10% to account for the difference in construction cost between the year 2010, which was the date of the bridge study, and the present year, 2012. Should also add that there's an additional safety factor in there, in that the original bridge costs, which we use the average of, already contained a 25% construction cost contingency. So the cost that we came up with was $298 per square foot of bridge deck, which we rounded up to $300 per square foot of bridge deck. So for a 20 by 30 foot highway type bridge, we identified an order of magnitude cost of $180. I'm sorry, $180,000, thank you. We think this cost is conservative for a number of reasons. As I say, it already contains a 25% construction cost contingency. These bridges were intended to be publicly bid, so typically the cost of private sector construction is less than publicly bid projects. And finally, I think that the length of the bridge that was discussed, which was 30 feet, could reasonably be decreased. I did make a site trip and observed the existing stream. I couldn't observe it on the project site and didn't have permission to enter the project site, but I did observe the stream on the adjacent lot of land, just where it passes under Ford Ranch Road. And in that location, the width of the stream was about 4 to 5 feet, and it was a few inches in depth. So I think it reasonable that a smaller bridge structure could be considered. Finally, I think you could consider something other than a bridge. In my experience, the Conservation Commission would likely be in a position to condition an open bottom culvert. And while I didn't include it in my memorandum, shortly after preparing this, I did have a conversation with a representative of Contech who does a number of prefabricated culverts. And the representative I talked to had just done a precast arch culvert structure almost exactly of the dimensions we're talking about here, a little bit bigger. It was 30 by 32 feet as opposed to 20 by 30 feet. The cost that he incurred in that particular precast structure was $110,000. I can't take responsibility for that cost, but I guess what we would take away is that another type of structure, other than a highway bridge, which I consider unnecessary here, another type of structure would likely be permitted by the Conservation Commission and could be constructed at a lower cost. I wanted to also just touch on the issue of the length of the dead-end common driveway here, which we've heard testimony is some 12 feet in width and 1,700 feet in length. I personally am a consultant to some 20 boards and commissions in Massachusetts, and I have written subdivision rules and regulations for 6 different planning boards. Last year, we had updated the planning board regulations in Blackstone in Norfolk. And in conjunction with that work, we had the occasion to do a survey of the dead-end street length in all the communities in Norfolk County. Your regulation of 500 to 650 feet is pretty much the norm. I can think, by way of example, Norfolk's maximum length is 500 feet. Other communities in Norfolk County are as short as 400 feet. I've seen some as long as 1,000 feet. I have never encountered a subdivision reg that has anything like 1,700 feet as a dead-end length. So while there is not uniform agreement as to what is the maximum safe length of a dead-end street, every community in Norfolk County acknowledges that it is a safety issue and does have some standard, and no standard that I know of approaches 1,700 feet in length. I think it's not really an engineering question, it's more a matter of common sense. Is a 12-foot wide, 1,700-foot long driveway an advisable or a safe way to develop this property when there is a viable alternative? And that is coming in from Ford Ranch Road. The cost information which we have is that it would not be unreasonable to construct a private driveway from Ford Ranch Road. And the advantage would be, in addition to being much shorter, you could set the width of the roadway at a reasonable width. If you were to say the new roadway would be 18, 20, 22 feet, it would not have a measurable impact on abutters. If you try to widen the pavement on the existing common lane, it is going to have a significant impact on abutters. If you concur with me that it is desirable to have access from Ford Ranch Road, my advice would be, and I echo Attorney Bobrowski's recommendation, and that is to preclude access along the common driveway from Hillside Street and to require access from Ford Ranch Road. What that does is it creates so-called limited project status under the Massachusetts Wetland Protection Act, and the Milton Conservation Commission is also bound to adhere to the regulations applicable to limited projects. Section 310 CMR 1053 3E refers specifically to a limited project as the construction and maintenance of a new roadway or driveway of minimum legal and practical width acceptable to the planning board. So if you require access from that location, you are making it thoroughly feasible for the applicant to obtain an order of conditions due to the limited project status.
Thank you, Tom. I would point out for the board, because Mr. Houston's too modest to say this, he's also acknowledged traffic engineer. He's testified for me as an expert witness on many occasions, including matters in front of the Housing Appeals Committee. And he's AICP certified, American Institute of Certified Planners. So he's a jack of all trades. I find him to be a bargain when I need somebody to testify as an expert witness. I'd like to ask the board's indulgence and for permission to have Mr. Whiteside speak, because I have reviewed with him his prepared testimony, and it does dovetail in if after we answer any questions, Mr. Chairman, that might be possible.
Okay, we'll entertain that. Why don't you have questions for these two gentlemen now?
I have some questions, but you can, okay. Just a few questions on the construction costs and some of your assumptions, and then one on the idea of precluding use of the driveway. So on the construction costs, it doesn't actually identify all of the costs that were considered in that. So does that include construction of the bridge, site work? What's included in that conceptual construction cost?
It is just the cost of the bridge.
Just the cost of
Yes.
the bridge itself, so none of the site work?
That is correct.
Okay.
Yeah.
And
If it is of interest, I could email a copy of that study to the board. I did include some selected pages from the study at the back of our memo, but we'd be
I saw
pleased to
those.
provide you with the entire study.
Okay. On the next page, when you do the cost increase from 2010 to 2012, what was the basis for using 5%?
It's lower than it actually is.
Okay. but why not use the actual inflation rate of construction materials?
Because we have to recognize what this is, which is an order of magnitude cost estimate. And in doing an order of magnitude cost estimate, we always try to be conservative. What we're saying is that the cost is $180,000. It's not $80,000, it's not $280,000. We're dealing with an order of magnitude. So we try to be conservative.
I understand that, but wouldn't being conservative be using the higher interest rate? I believe you just said that, or the higher rate of increase?
I'm sorry, I probably misstated that. The
Okay.
actual increase, from memory, is 3 to 4% during that period. So we used 5% to be conservative.
And that 3 to 4%, was that targeted to the Boston area market? Or was that a general
That's a
national
national
one?
figure.
Okay. And on that, did you adjust for differentials in labor and materials in the Boston area versus the Vermont area?
I did not.
Okay. And then the question on precluding access along the driveway, as I understand it, you're suggesting that the board say in our vote or decision that we should tell the applicant, you may not use the current driveway as access, you may only use Ford Ranch Road. Is that correct?
I think if I can
I
tackle
just want
that.
to make sure I understand. Yeah, either one of you, but I just want to make sure.
I think if you were to do that, you'd be setting yourself up for a legal quagmire.
Okay.
And I say that because it would be far better from my perspective to deny the current application and let the applicant reapply for Ford Ranch Road open space development. There's nothing, it's materially different. Clearly, it's materially different. Let that stand and fall on its own merits. If you were to do the opposite, condition this proposal with a drastic overhaul, the neighbors are going to walk away happy, and you're going to end up defending a lawsuit.
Then I don't understand, I think, your suggestion, Mr. Houston, about precluding the use of the driveway and requiring access along Ford Ranch Road.
I think we're saying the same thing. I'm just thinking it through from a legal perspective, that's all.
So say the applicant comes back and, okay, we're going to do Ford Ranch Road and put a bridge across it, and we have to go to DEP, and you're thinking, what you're thinking is by denying this, that DEP will say that driveway is no longer available for access. Is that correct?
Ms. DEP, there is no reasonable alternative means of access. Here's the denial from the planning board that says we can't use the existing driveway.
What about the Jepsons and the Corlises, who presumably are still going to continue to use the existing driveway?
I can only speak for the Corlises, and
Of course.
I can assure you that if this accessed off of Ford Ranch Road, I will not be at your next meeting.
Can I?
No, but, and jump in a second, but this is what's confusing me, is that presumably they're still using the driveway.
Yes, they are. But
So
what's
won't
done is done there.
DEP
No, what's done is done
Still think
there.
that's a reasonable access?
It's a reasonable access. The Corlises don't need any permission at this point in time to do anything. They have a grandfathered situation.
Oh, and I'm not changing that. What I don't understand is why the DEP wouldn't come back and say, well, if these other two families are continuing to use the driveway, it is still a reasonable access.
Well, there's a
I
big,
don't
there's a
think
big
that-
difference between coming in 800 feet to the Corliss lot and 1,750 feet to the back. That's not a reasonable alternative means of access to the back lot. It might be a reasonable means of access to the Corliss lot, but once you double the size of it, it's lost all reasonableness.
But it's already 200 feet to the Corliss, it's 800 feet to the Corliss's lot?
No, to the Jepsons, I think you mean to the back
You mean to
cul-de-sac.
the Jepsons, it's
It's more
800
than,
feet.
it's more than 6.
So this application stands and falls on its own merits, and 750 feet more is clearly beyond the pale.
You can jump in.
I
yes.
think I'm a little confused, too. I thought I did hear Mr. Houston say, which I thought Emily was indicating, that we should require that they use the Ford Ranch Road point of access. I thought that it was clearly stated that that's what he intended.
We agree.
You should tell them to use,
We
but
agree.
you then later say that that would get us in a legal situation that we can't say that.
We're-
So is it, we do say that or we don't say that?
I'm just trying to be helpful. We're splitting hairs. We agree that...
I don't think so.
Well, I'm trying to be helpful. I think we're splitting hairs. If you say in this decision, approved open space development, provided, however, access can only come in off of Ford Ranch, and they don't want to do that, you're going to be standing alone in defending that, because we're going away happy. If, on the other hand, you deny it and send a message to them that their next application coming in off Ford Ranch Road will likely meet with a much better result, you don't have a lawsuit to defend in all likelihood. Because this lawsuit, if you deny it, is eminently defensible. It's 1,750 feet on a narrow road. That's a very winnable lawsuit.
My statement was based purely on engineering criteria. I was saying it is not advisable to allow use of the lane off of Hillside Street. It is highly desirable to encourage access off Ford Ranch Road. Attorney Bobrowski clarified my statement only with respect to procedure.
Right.
I said try to modify the existing plan. Not being a lawyer, Attorney Bobrowski said it is desirable from a legal point of view not to modify the existing plan, but to require a new plan. There is no difference in our recommendations, which is not to allow access via the lane and to require access from Ford Ranch Road. It's just a procedural point that Attorney Bobrowski raised.
I have read the DEP regulations, and it seemed to me that they were pretty emphatic in the fact that if there is any alternative means of ingress, then you are to use that, period. And I think your indication that you don't consider this a means is, at this point, somewhat of an opinion.
Not at all. If the planning board conditions an approval to require access in a particular location, that is the only alternative available to the applicant. He can come back to the planning board at the Conservation Commission's request and ask you to allow him to move it. But if you say no, there is only one means of access available to the applicant, and that is along the route indicated on the plan approved by the planning board.
But Mr. Bobrowski has just pointed out that we cannot, in
Get
fact,
legal entanglement.
condition a denial on them coming in for another thing. All we can do is either approve or deny this. We cannot say in our denial that you are not allowed to use this driveway. We cannot do the one thing that you're saying the DEP would have to see.
No, I think we're talking past each other. If you were to deny the special permit application because you find the road entirely inadequate, unreasonable under the circumstances, in violation of your standards in the subdivision regulations, which, like it or not, serve as a guidepost here, if not a formally applicable regulation. I mean, certainly 1,750 feet is well beyond the 650 that would be permissible as of right if this was a subdivision. So you don't ignore that, even though it's not technically in front of you today, as town council said, as a subdivision application. That is the standard that you've set in town for the length of a dead-end road. So on that basis, you could say, we deny this plan, period. It's unsafe. If the applicant were to come in and go to the Conservation Commission after that and say, look, there is no reasonable alternative means of access, the planning board has spoken, we'd like to come in across the stream at Ford Ranch, that's exactly what 10.533E has in mind.
But I think there's two potential problems from DEP's point of view with what you've stated. The first is that you stated what our standards are for a dead-end road, but this is not a road. This is not a street. It's a major private driveway. There's a different legal definition for that.
It's not reasonable, no matter what you call
The
it.
second thing that the DEP will look at is that we have, in fact, set a standard for a major private driveway in an open space subdivision, and that was 2,000 feet.
Well,
And so if
each
DEP
project is different.
Each project is different, but if DEP is looking at a standard, we, the planning board, have set a standard.
In another location. They're not all alike, and they're not immediately transferable. In Lakeside Builders Corporation versus Planning Board of Franklin, the Planning Board of Franklin waived its dead-end limitations 20 times in a row. The 21st applicant was denied the waiver. He sued, saying it was a de facto rule change. The appeals court said, you're just different. Waiver denial upheld. So you're not locked in by the fact that in a previous open space development you gave a 2,000-foot roadway. This is a different site. It has different dynamics, different needs. And the Lakeside Builders case is immediately on point.
But then we're also not locked into the subdivision regulations, given that this is an open space permit.
Look, if you want to give the special permit, you're giving away the farm, as I said already. There's no as-of-right position here. They can't do an A&R, and they can't subdivide it without your waivers.
I'm just merely trying to understand your arguments at this point.
Yeah, that's my argument.
Can I just ask Bill one? Salamando's, Bill,
Yep.
Salamando's 2,000-foot driveway.
Yep.
What's the width of that? 20, 25 feet?
18 feet.
18?
18 feet?
I
Curbstones?
was wondering. about that.
Sidewalk?
No,
No?
Beautiful
no
bridge.
curbs, no curbs, no sidewalks.
A beautiful bridge, though.
There is a bridge.
Beautiful bridge.
The,
Second,
But
yeah,
can
well, for now, I
add
am.
one thing
I've
to
got
it?
1,000 more
Yes.
The
questions.
lights are at the driveway entrances.
We were
And on
going to
the
do that
bridge,
for,
Street lights. Yeah, they're tucked in the side of the bridge.
Nice.
weren't we going to do that at Brush Hill Road?
Yes,
16 foot or 14 foot at Brush Hill? I know you told me again.
14 feet.
14 foot with the lights at the end of the driveways?
Yeah.
Yeah.
The estimating you did, it seems like all of these bridges are rehabs, and that the substructure existed, because it says rehabilitation of existing substructure. It appears that they're all, and if the picture is to represent something, it appears that they're all rehabs. So my question, it seems rather, my experience is more in construction management, and it seems like you can't do much, very much for the price that you set here, but beyond that, what do you assume these bridge abutments for this new bridge are founded on?
The study did not include a surcharge for unusual soil conditions. If we were to encounter unsuitable soils underneath the abutments that have to be excavated out, my thought would be that the abutments are small enough, and if you assume a unsuitable soils depth of, say, 10 feet under the abutment, you're talking a cost of certainly under 10, probably under $5,000 to address that sort of unsuitable material cost.
In other words, you're going to
If
take out a
you-
depth of soil and come back in with fill and compact it.
Correct, yes.
And you-
If you encountered unsuitable material under the abutments,
So now you're digging in wetlands as well.
you would be digging in the location of the bridge. I don't have a detailed map of the on-site location of the bridge, so I can't tell you that. But if the abutments of the bridge were within a wetland, obviously, yes, you'd dig down within the limits of the wetland.
And again, I don't think your price includes a substructure. I don't think these bridges include it, whether they were founded on piles or spread footing. I think those existed.
Yeah. The three bridges that I selected, none of the abutments were to remain. There was one bridge where one of the abutments was to be rehabbed. There's a note here that says that that particular cost, it's note 2, that existing bridge structure, bridge abutment, I removed it and replaced it with the cost of the new abutment on the other side of the
Are
bridge.
you
So
on the one that's $181,000?
The one that dropped down to 156, yeah.
yes,
I'm looking at the one that's $181,000. It says rehabilitation of existing substructure.
that's correct. If you look at
So that, in this,
If you look at note 2, sir, which
Yes.
is at the bottom of the table, it says, delete
two.
rehabilitation of existing abutment and add construction of new abutment.
I'm not looking at the same page as you are.
It's on page 2. And
Yeah,
then
the
footnote's on
footnote
page 3.
appears on the following page. It's footnoted in, next to the number 156,000, and the note appears at the bottom of the table on the third page of the memo.
I wonder if they had to do all these bridges all over again after
It's
Irene
right
last
here.
year.
in this
Yeah,
case.
that's true. Makes sense for why it would be in Vermont, so in addition to no surcharge for soil conditions, you would also have no charge for wetlands mitigation if it were necessary to dig. I didn't read.
Okay, yeah, I actually did get to it eventually. Thanks.
Mr. Houston? So in addition to no surcharge for unusual soil conditions, as you mentioned, you would also have no cost in here for wetland mitigation if you were required to dig within the wetlands. Because the wetlands come quite close to Ford Ranch Road, so there's a reasonable assumption that, depending on how it's constructed, you might need to do some mitigation
Under the...
or replication.
Yeah, under the limited project status, you are required to replicate wetlands that are altered. I did not, this is not a cost of the entirety of the access road from Ford Ranch Road. This is just the bridge
Just the
structure.
bridge
Yes.
itself, and not the site conditions?
That
or
is
soil
correct.
conditions. Okay. All right, I don't have any more comments.
Yes.
Can the stream or the wetland be replicated on any other part of the land that the applicant owns? In other
Yes, they'd be replicated on the project site contiguous to the existing wetlands would be the typical requirement. So you'd be digging out
So
an
that
area
a
of
land
upland.
bridge could be built. In other words, a road could be constructed if you could get rid of those two, replicate the two fingers. Is it a lake? Is it a stream? What is it? It looks to me like it might be a river. I mean, how deep is it?
It's a wetland.
Well, I know it's a wetland, but, you know, you can replicate.
Well, they have a wetland specialist. Ask him.
Sir, I observed the stream, again, I didn't have permission to enter the property, but I did observe the stream where it emerges from the lot and enters the adjacent property, which I believe is number 72 or 92. 92 Ford Ranch Road. And at that point, the stream had been channelized with a little bit of trap rock. It was approximately 4 to 5 feet in width, less than a foot in depth. So that's the size. It actually was a drain pipe in Ford Ranch Road that accommodates that flow, and it's a 30-inch drain pipe.
You mentioned to put a culvert in with no bottom,
As an alternative, yes.
and then you could conceivably run a road across that.
That would be the
And then
idea, yes, sir.
replicate the damage that you've done to the marshy land. You could replicate it someplace else on the lot. And it would-
Well, the arching culvert, I don't think that would have to be replicated because that would be over the stream. What would have to be replicated is any wetland that you altered with the roadway approaching the
Right.
bridge or culvert structure.
With the 25-foot so-called no-build area?
You would have to, by definition, bridge that, yes, which again is one of the reasons that we would recommend that the approval of the project be structured such that the bridge crossing would be considered a limited project. It would be much easier for the Conservation Commission to approve it if it has limited project status. And one of the requirements of that limited project status is that the driveway or roadway is of the minimum practical dimensions permitted by the planning board, and secondly, that is the sole means of accessing the upland, which is why I mentioned the issue of requiring the crossing in that location.
When you say the sole means, in other words, the people that purchase these 3 lots and build then wouldn't use the existing road?
Yes, if a new common driveway, or whatever the correct legal term would be, the common driveway would serve the 3 new dwelling units.
And they'd be restricted from using the existing roadway? I mean, I thought I just heard you say that would be the exclusive and
Yes.
only means. So in other words, if that's the exclusive and only means, then
Yes,
the
that
roadway
is
that exists,
correct.
they'd be more or less restricted from using that.
Yeah, that would be correct, yes.
Which would involve, in terms of, if you were going to alter, if you were going to approve it, but require access only off of Ford Ranch, they have driveways shown coming off the private roadway that are not on any plan in front of you today, and there are other considerations. I don't even know that they would want to maintain the same lot layout if they were to come in off of Ford Ranch. I think they should have the opportunity to reconfigure the plan coming in off of Ford Ranch without you having to do the heavy lifting of guessing at what the permutations will be, which is the only reason I suggested that I thought it would be cleaner to deny it and let them come back. It's without prejudice. They can come back with a Ford Ranch open space development plan. We're signaling that we would not oppose such a plan. I think it really boils down to cost and safety at this point.
Just a question on the ability to use or not use that driveway. Of course, the current the people who live there now, who have permission to access it, would still be able to access it, as you said. Presumably, the current owner of that land would still be able to use it for access.
He owns
So
it.
the planning board can't prohibit the current owner from using that.
Right.
I'm still a little unclear as to how, if the planning board denies this, that DEP won't look at the rights of the current owner, who has the right to use that to access his land in the back. He owns the whole entire driveway.
Yep.
He owns the land in the back. He owns that other parcel that's sort of in the middle.
Yep.
Why wouldn't the DEP look at his current right to own, right of ownership and to access?
It's two separate questions. Right now, he's accessing the backland using the common driveway
Which he owns.
for the purposes for which it's being used today and nothing
Right.
more. If you approve the plan, it'll be the site of 2 additional houses in the back and another one in the front. There's a difference in degree in terms of use of the common driveway and characteristics of use that would be approved by this board if you were to give the special permit. And by that I mean, there's considerations today. You're not going to get a fire truck back there in a hurry and care. If the trees catch on fire, who cares?
Well, I think I'd care if the Jepson's house caught on
I
fire.
understand that,
800
but when you go well beyond that to the back where Lot 3 is located, that's an entirely different kettle of fish.
And actually, I'd kind of care if the trees catch on fire, because there's a lot of houses in that area, and a forest fire in that area, it would be,
Not saying you wouldn't want to put it out, I'm not saying you wouldn't want to put it out fast, but if an ambulance has got to get back there 14 times, that's a different story.
Then possibly the solution is make the road larger, make the road 20 feet wide.
It's still 1,750 feet long.
Oh, the driveway, not the road.
what, and I'm picking on you a little because I want to make sure that I understand your arguments. You said it would be a different use of the driveway in the future. So what is the driveway being used for today?
Well, it's being used for access to the existing homes and to the
Okay.
owner's backland.
Okay. And so and presumably it's got utilities running underneath it. We know there's cable and water.
And
all
at
of
some
that.
point in time, this board made a determination that that was a reasonable and fair use of the driveway.
I don't know that the board made that determination.
Well,
I think it
the barn
happened
door's
legally.
open.
Right, but it's being used to access homes.
Right.
And it's being used for conveying utilities. So how would that use be changing in the future? Presumably, yes, it would be used to access 3 more homes, but it's still being used to access homes.
Well,
It's not like, suddenly we're putting a
You're ignoring-
20-story office tower.
You're
there.
ignoring the fact that the last home is going to be at least 1,750 feet back
No,
there.
I'm not ignoring that fact. I'm asking you about the usage.
That's what's different.
So you're saying that the sole difference between now and potential future is the length of the driveway?
And
That's
the
only
lack of
thing.
safety associated with it.
And why is the length of the driveway associated with lack of safety?
You tell me you have a 650-foot dead-end limitation. Why did you put it in your subdivision regulations?
I wasn't on the board when we did the
Every
subdivision
board has it.
regulations, so I
It's
can't-
always associated with safety for access for fire, police, and emergency
But
vehicles.
the fire chief has already said that he considers it perfectly safe.
At some point, with all due respect to the chief, 1,750 feet speaks for itself.
You haven't explained why. The fire chief says with turnouts that he sees this as being perfectly safe. Explain to me, in simple language, why this is not safe.
When when the April Fool's storm came in 1997,
Yeah?
I lived 4 houses away from the Mansfield town manager. He
Okay.
had announced his resignation. The DPW didn't like him. 3 trees came down, and we couldn't get into our neighborhood for 4 days. They weren't going to plow it out, it was payback. So if a tree comes down across a 1,750-foot dead-end road, and you can't get a fire truck, an ambulance, and a police vehicle back there, that's why you have dead-end limitations.
I see. Okay.
I might add, I guess, the answer depends on the question. And it would be interesting to know the response if the question had been to the fire chief, would you prefer a 1,700-foot-long, 12-foot wide roadway with turnouts, or a 20-foot-long roadway constructed, paved to that full 20-foot width with a length half of 1,700 feet? I mean, it depends on the question. And I'm sure the fire chief would prefer the wider, shorter, newly constructed roads, so.
That brings me back to your bridge. I think we're going to have to add some money in there to get a fire truck across that bridge.
The last thing I want, the Supreme Judicial Court has upheld a dead-end limitation of 400 feet for the rationale that I've offered you in a Winchester case in the 60s.
Braintree actually has 400 feet. It's a dead end.
Interesting. For a dead-end street.
Yes.
Any more questions at this
For
time?
now.
Yeah, I think we're okay for now.
Okay, you wanted Mr. Whiteside to come up?
With your permission, Mr. Chairman.
Yes, we like Mr. Whiteside. Come on up, Mr. Whiteside.
Hello, Alexander Whiteside. I did a sketch of what the driveway
Okay.
coming in off Fort Ranch Road would look like. And outlined in red. And I'll put it up on Mr. Hannigan's easel. If I can. And what I did in determining the length, you'll see that I say this little street coming in off Fort Ranch Road is 720 feet. So I took Mr. Hannigan's scale and I used a ruler and came up with 720 feet. And then you can see that I've made the claim that what they're proposing is actually not 1,750 feet, but 1,960 feet from Hillside Street to the lot line between lots 2 and 3. And your major private driveway is going to end where the driveway to lot 2 goes off at. And since there's no showing on the plan where the driveway is going off, it is possible the driveway might go off at the circle. Therefore, I see that there's a potential of a 1,960-foot-long road, and I see a clearly superior 720-foot roadway. So I think that the board would do well to approve the Ford Ranch Road access. The question of whether or not you should just deny the plan rather than approve the plan on the condition that access is gained from Ford Ranch Road with a finding that the access off Hillside Street is not a reasonable access, would seem to me to be, might be a nice way of doing it. And so I would, that's what I would recommend. And as I say, major private driveways describes the portion of the private driveways that runs by the individual homes as opposed to the section of driveways that run toward the homes and terminate at the garage. So the length of the major private driveway really depends on where the driveway to Lot 2 goes off, because once it goes off, then the remaining driveway is simply the driveway to Lot 3.
So if it went off here, this would be the driveway to Lot 3.
Maybe they could reconfigure the lots too.
And it would be, I think that, in showing where the driveways would be, the plan probably, undoubtedly, should show where the driveways are. And in doing so, they should have building envelopes. And on Mr. Hannigan's latest modified plans, he has described building envelopes of the following size. Lot 1, 1.3878 acres. Lot 2, 2.2067 acres. Lot 3, 1.5533 acres. I would suggest that a building envelope should be no bigger than 10,000 square feet, and that these huge envelopes, which aren't even delineated on the plan unless it's just the setback. I don't know where they come up with these acreages for building envelopes, but the plan really needs to show where the houses are going to be, and obviously the plan needs to show where the driveway to Lot 2 goes off so we can determine the length of the major private driveway. And that's why I was pulled up when I was to share with you this plan. I did send you a email today on, I sent it to Mr. Clark with the request that he communicated to the board. And it has to do with Mr. Flynn's opinion that this is not a subdivision. And although I disagree with his opinion, I think that you're probably going to go along with that, and I point out the problems that the current plan has. The A&R endorsement has to, above it, where it says subdivision approval not required, it has to say something to the effect, subdivision is not required because this is not a subdivision subject to the subdivision control law. That's fine. Not that I think it's right. And I think Mr. Grabowski is right in saying that endorsing this as not being a subdivision is sort of a legal slam dunk. But the problem you have is what they've done is created a Lot A. Do you see Lot A on your plan? Now, Lot A is not part of this open space subdivision because, of course, it doesn't have 4 acres. What it is a traditional lot with frontage on Ford Ranch Road. And they've tossed it into this open space development plan, even though it doesn't qualify as part of the open space development. And it can't be approved for the same reason that it's not subject to the subdivision control law, because it obviously is. So the plan, the way to have done this would have been to approve Lot A separately, and then with the rest of the parcel, do your open space development. This is just procedurally a nightmare. Let's see. It would have been better, it really would have been better if when the fire chief went out with the developer, the neighbors had been invited to go along and ask some questions themselves, because we have Marion saying, well, the fire chief said this, and he said that, and he said, and we, I mean, it was only the developer who was there, so I assume that he probably did say these things, but he may have had a slant on them that someone else could have picked up on. But there are no other witnesses. The covenant. The covenant, well, Mr. Clark was there, but Mr. Clark supports the developer. So I have to say that I'm not sure that, I think that you're the impartial person that was needed. The covenant, when they say, well, we'll make the covenant bind the existing owners, and I question, how are you going to do that? How are the existing owners are not a party to this plan. They're not subject to this planning board's jurisdiction. How are you possibly going to bind them to a covenant? And the answer is you can't do it.
I don't, sorry to interrupt, but I don't see the existing owners mentioned in the covenant.
What?
I don't see the existing owners mentioned
Well,
in the
it's
covenant. They talk about the new owners, but they don't talk about of lots 1, 2, and 3.
well, they talk about the owners on the existing pavement, don't they?
I don't believe so.
I think they do.
No. The only owners that are defined are the owners of lots 1, 2, and 3.
Well, and so you think this says that they're going to do all the maintenance and all the plowing?
I'm just questioning your reference.
Well,
current owners that are not in
they're
here.
saying that later on it says they'll do a proportionate part
Yes.
of the plowing and maintenance, and obviously the board wants to make sure that there's plowing and maintenance. But quite apart, whatever the state law may be as to maintenance, if someone goes out and paves a road over the objections of his neighbors, and then someone says, well, you've got to help me pay for the maintenance of this paved road, I'd suggest that you have a delicate legal situation, which is not at all obvious. I don't think the covenant, which attempts to bind the existing owners, is likely to be legally enforceable. So I think it needs to be reworked. At the very least, it needs Mr. Flynn's careful attention. So, thanks.
Question?
Yes.
What is the distance from Hillside Street up Ford Ranch Road to your new roadway and off of Ford Ranch?
I don't know, but you must have measured it. But
Well-
Ford Ranch Road is a 30-foot paved street with 2 sidewalks, one on each side. And it is really, I wouldn't be too worried about Ford Ranch Road.
I have measured it. In these numbers that keep going around, I measured roughly about 1,650 feet back to the property line at Lot 3 on the proposed private driveway.
Really?
I started to measure here, and I could just get the dimensions right off the drawing, 300, 500, 700. It's probably close to 800 feet back to there, so if you're 800 feet back to there and 900 feet in and off the road, you...
Well, one thing to get yourself into the the 600 feet situation is, assuming your driveway to Lot 2, if you do your circle right here, and then your driveway goes off here, then your major private driveway, you could bring it in at 600 feet. You could meet the standard, and...
Well, in fact, doesn't the standard say that it has to be less than 650 feet off of a road that can bypass in either direction, like Hillside?
Yes, it says that the dead-end street,
So here's my point.
you're saying that you will combine Ford Ranch Road with this and say it's even longer than coming in.
Well, we can say it's the same if you want, or slightly less, I don't care. But everybody got up here, Mr. Barbowski, the engineer, they said 650 is even in the realm of typical, probably lengthy. And they also indicated very specifically that that is based on safety, period. And that's a road. That's not a private driveway, that's not whatever, that's a road.
It's a street.
It's a street, road, whatever. Now,
Precise.
everybody has decided that this 1,600, 1,650, 1,700, whatever you want to call it, private driveway, the problem is safety. So if we use the access off of Ford Ranch Road, in my mind, you're in the same situation. You have a dead-end road that's 1,600, 1,700, 1,900 feet in. Mr. Borowski's tree fall down is going to have to cause the same
They don't have
problem.
many street trees on Fort Ranch Road.
That's not what was expressed here. They expressed
And
650
it's
feet
30
based on safety,
It's
period.
also 30 feet wide with two sidewalks.
I think it scales larger than that. But that's,
With a 50-foot
but
layout.
that's not what the zoning says. The zoning does not say if the road is 100 feet wide, it can be greater than 650 feet. It does not say that. It says 650
I do
feet.
think a 30-foot public street
My-
is different from a 12-foot private
I don't think
driveway.
anybody would, but basically, the problem is, if you want to apply the safety situation on 650 feet there, but you don't want to apply it here, I don't see the logic.
Well, you can turn around on Ford Ranch Road.
But that's not what it says, Bertie. It says 650 feet. And your fire truck has to get down Ford Ranch Road, turn over your new 20-foot bridge, and get his way in there. He's running into similar situations. I mean, the road that exists today, the private driveway to the cul-de-sac that exists today, is probably further than the dimension from Ford Ranch Road to this new road,
But you're coming off an accepted street.
off a hillside.
Right.
So why are you off the
No,
private
the
driveway?
accepted street is Ford Ranch Road.
But that shouldn't be more than 650 feet, Ford Ranch Road.
The definition of, I mean, Mr. Kelly has a point, which is because if you were building a street, if this were a street, and this of course would impact their ability to do a subdivision, because if you were building a street, the subdivision rules and regs would say you measure your dead end from here to Hillside Street. And I see the difference between a 12-foot driveway weaving in and out among existing dwellings, and you're not going to pass any of those dwellings. You're going to pass the people who live on Ford Ranch Road well set back. You're not going to go through the McDonough's hedge. You're not going to do any of these things. You're going to bypass all these houses with a nice, clean access from Ford Ranch Road. And to me, it would make sense if this board were to approve the plan, provided that access be from Ford Ranch Road, and make a finding that the access from Hillside Street is not reasonable.
Just with, again, with the reasoning what you just used, if it goes to the DEP says, well, if the planning board has decided that, and I'm going to use it for conversation purposes, 1,650 feet off of Hillside on the private drive, even though they were allowed to just, widen it if they decided to tell the developer you need to make it 20 feet or 25
But
feet.
why would you destroy the
Let
neighborhood?
me just finish. If that went to the DEP, and you just told the DEP that it's unsafe to go 1,650 feet, even if we widen it to 20 feet, but yet we're going to go 1,600 feet off of Hillside and go across your wetlands, and that's the reasonable way to do it. Aren't they going to say, well, why would we allow you to do that unsafe condition if the planning board wouldn't allow you to do that unsafe condition?
Well, I think that what you're saying is...
Beyond the fact that you're destroying our wetlands
Well,
creating the same unsafe condition.
This bylaw was meant to preserve open space. It was meant to be something that people would be pleased to have. To require that the driveway be widened to 20 feet to make it safe, and then plow it through the existing house and destroy the neighborhood just for whatever it is, isn't reasonable. It's not safe access, as Mr. Bobrowski points out. We have a 650-foot street limit, and, you know, the application is the same. There, if you want to, I mean, if you want to, you can approve this, but when there's a good alternative that isn't going to destroy the neighborhood and make everyone there very, very unhappy, why not take it? It just seems so logical.
That's with the assumption that they can get by the DEP and it isn't cost prohibitive. I personally think the estimates for the bridge, I mean, I'm not involved with design, but I'm involved with construction every day, and my God, you can spend $180,000 in about 2 weeks out there.
Look, if you approve this, subject to there being access to Ford Ranch Road, they design it, and the finding that the access that you provided is not reasonable, then they go directly, I mean, they get Mr. Hannigan to work his magic on a plan, but I've helped him out. And the Conservation Commission will then, you know, make known this, whether or not they buy it or not. I think they will.
I think we're possibly forgetting one thing, which is the applicant has not put forward Ford Ranch Road as a possibility. And that's fine, that's their choice, but I don't think we can then approve based on them going to Ford Ranch Road. I think your choice, the choice of the board,
as a condition?
is either to approve or deny. Yeah, they haven't offered that as an option. In fact, they've said that they're not going to do that.
But that's what conditions are all about.
Yes, but that's not a condition that's on the table.
Let me ask this, what's on the table? If we reject this and they go to the Conservation Commission and go through the DEP process, and even though your opinion is they'd be fine, they're not fine, then they're pretty much in a bind. They've been shut off from both directions now.
Now, just on conditions, I mean, I like the idea of approval with a condition, and I know that we do all kinds of conditions on our special permits that we come up with ourselves. The fact that they're not on the applicant's plate initially doesn't mean they don't end up there.
We do all sorts of conditions, but the conditions are usually agreed to by the applicant by the time we get to the point of writing the decision. In this case, we have not heard the applicant agree to this sort of condition, and we would have to know whether or not the applicant agrees to that condition before we could go forward.
Is it possible, and I know people don't want to prolong these things, I'm starting to see why they get prolonged. Is it possible to have the applicant address it, whether they care to put this on hold,
Yeah.
look at that? Because, like I just said, if we reject the use of the private driveway, and they're rejected by the Conservation Commission, then they're stuck. I mean, there's always another way to skin the cat, but it's certainly shut off some significant avenues.
We could say, look, we want this addressed. They could come back. The issue will be the same as the issue at the beginning, which is whether or not it costs them more money to put the bridge up, and therefore how they're going to cover that cost, and it comes to, does that mean they're going to do further development? I mean, it's a question to ask them.
Well, I think step one would be just the simple question, would the Conservation Commission allow the bridge, period?
I don't know the answer to that.
Before
So
you
we could
even-
ask that,
I mean,
yeah.
before you even,
If we didn't want to clear this up tonight, we could ask that.
before you even look at the cost, there's no point looking at the cost if it's not going to be feasible.
I think your first question is of the applicant, do they want to ask this question?
Right.
If it's
Or do they want to put it to vote? Let the
Exactly.
chips fall where they may.
Mr. Bobrowski, come up, please. Al, you can stay there, please.
All right.
Mr. Chairman, I hear, the applicant will be stuck, and I get that, but they're stuck today. They don't have an as-of-right. They're here to ask you for clemency. Unless you give them something, they have nothing. So they're stuck today. And if they can't do Ford Ranch, they're stuck just like they were today. And ultimately, that's the bottom line.
Well, I don't know that they're stuck.
They're
because
stuck today. They have no as-of-right position.
Well, I think possibly they do. I think there's a bylaw in the zoning bylaws that very much addresses this
It's a
situation.
special permit. They have nothing as of right unless you give
Yeah,
them a
well,
special
okay.
permit.
But they do
All right.
have the right to apply under the special permit.
Of course they do, but you
It
have the
is-
right to deny under the special permit. Even a plan that could have been approved for reasons like we're talking about here this evening can be denied. And if you want 4 sites on that, I'm happy to give it to you.
Thank you, sir. Thank you.
There's a very simple situation here. I respect the neighbors, I respect the neighbors' wishes, I ultimately want them, like Alex stated, the best deal is the deal that everybody likes, on both sides.
Marion, do you want to come up?
But there's
This point.
also the right of a person who's been paying taxes and own land.
Well, when I come, I'd actually like to bring our wetlands consultant who's here and ask my...
Well, it just-
I will
We should hear
address
from
this point,
their
but it's
consultant.
related to all the other points, so whatever way you want me to do it. Two points I'll come up with.
Come up, Marion.
All right.
Thanks, Al.
First of all, Mr. Whiteside has stated that we're in here with an application for an open space development permit and a lot. That's not true. We're not applying for any permit, we're not applying for anything for Lot A. It's just on the plan to show you what we were trying to do here, was to show you that you can still have open space development permit and have enough upland and have 4 lots and have over 4 acres and create this additional lot. And the reason we created the lot was to show the board and the neighbors that it would be possible to purchase that lot and provide control over that piece of land if that's what they want to do. To date, nobody has indicated an interest. That doesn't mean I'm told that it's over, that it's still possible. Neighbors may be interested in doing that. So we've left our plan in its amended form. We are not applying for status, A&R status for Lot A. So you can just take that right off the table. We're applying for an open space development permit for 3 lots in the rear of this property, as it is in this plan. Now, in fact, I agree with Mr. Whiteside. If we were trying to do the 2 things together, it would be exceedingly confusing. It was no one's intent to do that. Mr. Hamilton is not interested in doing that now, and I just want to make that crystal clear to you. And never did, and that wasn't the purpose of drawing the plan this way. On the other discussion, I mean, first of all, I can't believe we're sitting here and talking about an alternative development plan that nobody has proposed. I mean, I understand that these are concepts that we've all been thinking about. The neighbors are thinking about them, Mr. Bobrowski's thinking about them, the engineer we brought in is thinking about them. And we attempted to think about them when we wrote you 2 memoranda, or at least one, about, I think I wrote two because I revised my first one, about what were some of the things that you could do with this property if you didn't do this open space development plan. They were conjectural. They were, I think these might be possible, I think this might be possible. Can you do some A&R lots? Can you do a subdivision? Could you, and I didn't elaborate on this, but I know that you can do this, can you come in and ask for a waiver of all kinds of provisions under the 40B affordable housing law? There are all kinds of possibilities for this lot. It's 15 acres of undeveloped land. It currently has frontage on Ford Ranch Road, and it has a driveway with a 30-foot wide easement that's owned by the owner. So I'm on that point, I'm back where I started from in presenting this application to you. There are a lot of options for what can happen with this property. Your applicant has brought this to you saying, I'm willing to do only 3 lots. I can do that because we have provision 6M of our zoning bylaw. It's called an open space development permit. The burden on the developer is he has to create 4-acre lots. They're much bigger than what he would normally have to do. What makes anybody think that a developer who comes in from Ford Ranch Road is going to want to do an open space development permit and sacrifice the additional acreage? That's been my point from the beginning here. There are indeed significant issues to contend with if any access is sought across Ford Ranch Road. It isn't simply the question of creating a bridge across a 5-foot or a 4-foot stream. It's a question of crossing a whole lot that's mostly wetlands. will DEP, if they were going to let you do, if this were the only alternative, what would DEP require? And it isn't the only alternative. Will DEP require that you build a bridge across the whole lot? They may indeed require that, because DEP doesn't like the idea of filling in 270 feet of wetlands to create a road for general traffic to go into this area. They may require a bridge, and the bridge isn't going to be 10 feet long or 30, it's going to be 250 feet long. We haven't developed an estimate. I have to say, I appreciate the estimate that's provided to the board, because it gives you an idea of the minimal cost just of spanning the stream. And that's what those bridges that we use for comparison, those are pedestrian bridges and light truck traffic bridges. That's the kind of bridge you put in a park so that maintenance trucks can go in and everybody else walks across it. We're talking about bridging the stream with something that fire trucks and heavy trucks and regular traffic can go on, and we're talking about the cost of bridging the entire wetland. Of course, the applicant has thought about that. Of course, they have considered what they would have to do if they needed to go in from that access route. And their conclusion is they would have to do more lots. I mean, that's as far as it's gone. The applicant is Todd Hamilton. He lives on Harlan Street. He doesn't think you should create more lots in this back area. All it will do is create a conventional subdivision and a piece of land that looks like the conventional subdivisions that have already been done up on Hillside Street, which are very nice. But they don't look like the old Hillside Street. They don't preserve the look of the area. So that's why you have this application. You have the bylaw, you have the application that appears to fit all of the requirements of the bylaw, and you've struggled, and we have, with how wide should the driveway be to be safe? What do we really need here? We've had the advice from the fire chief. We're willing to work with a 12-foot width. That would be the absolute minimum, by the way. 12 feet is the minimum width that you could use. But we'll work with it. If you do a 12-foot width, you can be sure you don't have to cut down the hedges that the Gunners have planted well into the right-of-way, and for good reason. No one was using that area. They wanted privacy. They built those. I like to see them stay there. You can increase the width of the driveway a modest amount and probably still leave the hedges in place, very modest. If you want it to be much wider, you're talking about removing the hedges or moving the edge of the driveway over, which requires that the neighbors on each side of the driveway want to do it. We don't have control over that, but we are willing to do it if the neighbors want to do it. So that shouldn't be the issue that controls everything else in this determination of what's a safe access for this development on the back. I think there have been a number of comments made about the wetlands bylaw and its application. If you're willing, I'd like to ask Lenore White to come up and sit here with me. She's our wetlands consultant, and she may be able to answer questions as well as me. So, is that all right?
Yes, yes.
Thank you, Mary. And as a background, my name is Lenore White. I'm a professional wetland scientist. I have a company in Plymouth called Wetland Strategies, which I incorporated in 2006. Prior to that, since 1981 through 2004, I was an employee of Mass DEP. I worked in the wetlands program. I was one of the senior wetland staff people there, and have seen many, many projects that propose limited project crossings. And I will assure you that in all my years and in all my experience, the fact that there's an upland access owned by the same owner available would dictate that that is the access that gets used. And that's under the DEP regulations that the attorney had pointed out, which is 310 CMR 10.53 subsection 3E. Now that's only in terms of the Wetlands Protection Act. If Mr. Hamilton were to contemplate a crossing at Ford Ranch Road, he would also be required to obtain a Massachusetts Water Quality Certificate. He would have to go to the Army Corps of Engineers to get a Category 1 permit. he may also need to go back before DEP for a Chapter 91 license if it's considered in navigable waters. And in most of those permits, the first question that's asked is there a reasonable alternative via an upland access to get to these lots? And the answer is clearly yes. And so in all of those forums, that question would come up and the answer would be yes. And I don't think there'd be any wavering of DEP's position to the extent that they recognize that there's this upland access available, and that would eliminate any of these impacts to the stream and the wetland area that exist off of Ford Ranch Road. And I find it interesting, just as a point of interest, that I'm sure that there are abutters who would be sensitive to this project should it be proposed from Ford Ranch Road. We've heard from the abutters off of Hillside Drive, but I suspect that if a proposal were in front of you today with an access off of Ford Ranch Road, you might have just as much dissension from the neighbors on Ford Ranch Road.
Thank you. Questions?
Yes. You've mentioned that the DEP would be looking for access that is reasonable, upland access that would be considered reasonable. We've had Mr. Borowski representing Corliss's say that it would not be reasonable because of the length and the fact that it would not be safe due to the length, whether there's a tree falling across it or presumably passing cars or whatever. Can you define what the DEP would use as a reasonable standard?
Well, they would certainly look at the opinion of the fire chief. I mean, that is the expert here in Milton, most likely, on safety issues and getting vehicles to streets and access to homes. And I would wholly expect that if the fire chief put that position in writing, that would certainly carry a lot of weight with DEP in terms of whether or not it's reasonable and whether or not the safety concerns of the town have been satisfied.
Okay. What about the planning board's rules and regulations and either the subdivision rules and regulations that we use that has a 650-foot limit, or past practice in the open space development with the 2,000-foot limit, or does the DEP not actually look at either of those but considers safety access?
They would consider that to the extent that the regulations require that when an applicant files a notice of intent that they have applied for or obtained all other applicable permits.
Okay.
So DEP would look to those permits to see if there's any constraints that were imposed in any of those permits to see whether or not this is a reasonable access.
Okay.
So in other words, I think what I heard you say is if we said this is unreasonable in length, then the DEP would accept that and say, well, that's not an alternative means of access then.
Possibly. I mean, they're not looking at the length of it, you know, they would be looking at whether or not there's alternative access. So I think their response would be, well, length is not necessarily a concern to them. So, you know, if the zoning board denies a permit, then clearly the project cannot go forward unless he appeals that and there's a final ruling in that matter. They might choose to stay their review while the applicant proceeds with a possible appeal to get a final decision from the town and/or the court.
And say, again, this is hypothetically as we're trying to work out the processes, say we deny it, the applicant comes back and says, okay, well, we are going to go through Ford Ranch Road, remember hypothetical, and the DEP looks at it and says, well, you have this upland access, and the applicant says the planning board denied it because they didn't feel it was reasonable. Can the DEP override that and say, well, we do actually feel it's reasonable, or it doesn't just depend on the case?
Yeah, it depends on the case, and it depends on how that denial was written. It depends specifically on what, you know, how it was denied, whether or not it's been appealed, and on what. So there is some wiggle room there in their discretion.
I think I heard you say on that point that they might say that there's grounds for appeal and that you should appeal it. We'll sit back and wait and see what happens on your appeal.
Right. The applicant can opt to request DEP to stay it until he gets a final decision.
All right.
And they would certainly allow that.
So it's both not an automatic acceptance, but it's also not an automatic override.
Exactly.
Okay.
But I think it's important to consider that when and if the applicant were ever to propose that access off of Ford Ranch Road, as I mentioned, there are a number of other permits he would seek to
Right.
obtain. And in particular, the water quality cert permit as well as the Army Corps of Engineers permits require that the applicant conduct an alternatives analysis. Some of the criteria in both of those permits are the same, because when DEP adopted their water quality cert regulations, what they did was look to the federal 401 application process to kind of make it a streamlined process, if you will, so that the alternatives analysis under both the federal permit and the state permit are the same. And one of the criteria is cost. That's clearly spelled out in the regulations. So what the applicant would need to demonstrate, which frankly the abutters have done in some way for us, is that the cost is significant to put in an access off of Ford Ranch Road. And it may even be prohibitive to the owner to do that. So cost becomes an issue that the regulatory agencies will look at and decide, based on the project purpose, whether or not the cost is prohibitive or not. And for 3 homes, it very well may be prohibited.
I don't understand, why would the regulatory agency care what it costs?
Because it's part of the regulations in the 401B guidance to applicants. There's 4 criteria for consideration. There's cost, there's logistics, there's existing technology, and there's potential for adverse impacts. So the alternatives analysis that an applicant has to do has to address all of those factors and demonstrate why the alternative that they choose is the most suitable. So cost is, now clearly articulated in the regulations as one of the criteria to be used in the alternatives analysis.
So in other words, if they said, well, it cost $1 million to get across here, what would the regulatory agency, how would they address that? They'd say,
Well, that's obviously only one factor, but I think what the applicant would demonstrate at that point is, look, for 3 houses, if it were to be $1 million, it's simply not practical. It's gonna cost me far more money than, so it becomes off the table at that point.
Anything else, Mary?
A couple of things I didn't address, which I intended to. One was Alex raised some questions about the draft covenant that I had prepared. The covenant is definitely not intended to require that any existing residents take any responsibility for something. We can't ask them or force them to do anything that they're not, they might be. They might have to cooperate in deciding how to maintain the road. So the covenant, and I don't think there's any specific language in there that says that. Alex did raise the question about maintenance of pavement, and he makes the point that if you permit an open space development and you require that there be 12 feet of pavement, that there will then be a paved road, and in the future the pavement will have to be maintained. Now, why should that become the responsibility of the existing homeowners? I'm not sure whether it should. And I'm willing to address that in additional language in the covenant. I do believe that I simply had not thought about it, but it's a good point. I suppose what you would do would be that you would require that 100% of the pavement maintenance cost be attributed to the new houses, because the pavement's being put in to benefit the new houses. And there would have to be language written. It's a draft anyway, so there could be other changes that would be required as well, but I just wanted to be very clear that there's no intent to require, and there can be no requirement that those with the right to use the road have to share any additional responsibilities with maintenance or so forth, because these 3 new houses are being built and there's an extension built to the roadway. One other general point I guess I'd like to make is we've talked about 2 different access routes, and that's because this lot has frontage on Ford Ranch Road, and the owner of the lot owns the driveway that comes in from Hillside Street. So those are the 2 permitting scenarios, I guess, that you can think about that exist now. because of the way the land is zoned. And given those scenarios, depending on what might happen with one alternative or another, both cannot result in the lot, 15-acre lot, becoming what you call a derelict parcel. Because that then becomes a taking. And that will not happen. What will happen is that at some point in a court proceeding, most likely, if it really gets that complicated, and the planning board will be well out of it by that time, I suppose, may come back to you, but the court will say, you have to be able to use your land. So there's going to have to be some give one way or another. How it's going to be resolved, I can't tell you right now. If it comes down to a conflict between, the conservation, the wetlands bylaw, DEP, and the local zoning issues and so on and so forth. But it is not a case of the land being able, that is not going to happen. So the third possibility, which I mentioned at a previous hearing, which is not before us, is that another access becomes available because somebody purchases a piece of land from another direction. Again, the point that we're making here is, if you permit this development now, you are going to have 3 lots, not more than that. 3 lots, 4 acres each. As narrow a driveway access as you can possibly permit and still feel that it's safe. And that will be in a special permit issued by the planning board with lots of conditions. There will be a certain amount of control over what the driveway can be like, and there will be control over what can happen to that back land. It will be 3 lots. That's the purpose of coming into you with this application. We've heard a lot of different evidence. Lots of legal issues have been raised. I think Mr. Bobrowski has tried to suggest that, that we can't follow section 6M. I think town council has given you a letter saying that's not correct, that you do not have to apply the subdivision control regulations to this because it's a special permit. And I've tried to take you through, with my memo that I gave you, take you through the steps that you have to follow in order to understand how to read the bylaw, read the subdivision control law, read the regulations, and come up with a result that doesn't throw out one part or another part, and makes sense in terms of the way cases have been decided that have looked at whether frontage is adequate for A&R lots on some type of way. What kind of things do the courts look at? They look at whether a vehicle can traverse the road. They look at whether public safety vehicles can get in and out safely. They say that, it doesn't have to be the ideal roadway, the perfect roadway from a planning board perspective. It needs to be adequate. And from your perspective, you have more control than that. You're the planning board. You decide what this driveway should be like. And you have the ability to say it should be of a certain width. It needs to be paved. It doesn't need to be paved. These are some of the things. It doesn't need to have lights. It doesn't need, or should there be some lights at driveways? These are some of the issues that you look at. I imagine that you looked at it when you did the development off Woodland Road. And, you chose a particular type of driveway configuration that was suitable for that kind of estate development. It was in the woods. It's hidden away. They're huge, beautiful grand houses with a lot of landscaping and a lot of stone walls, and you chose a certain type of roadway. That's only an 18-foot roadway. To me, it looks like a pretty big road. It's amazing. I guess it's because it's so engineered. Incidentally, that crosses a stream, and the reason it can do that is there is no other way into that back area. That's why that was allowed. And the controversy that existed with that proposal was a wetlands controversy about the presence of endangered species and things like that, and it was actually a wetlands appeal, but it was resolved in favor of the developer. So I think, I don't know how much to get it, I tried to say over and over, we're not proposing a bridge at this point and so forth, but I think the point's been made by the questions that have been asked. We've got kind of a minimal estimate of a bridge decking cost to go over a stream, but we don't have any estimate of what it would cost to cross the wetlands, and the lot is covered with wetlands.
Right, there's substantial impacts that DEP would look at when you propose any kind of crossing. They include the footprint of the bridge, they include shading impacts, they include where, if possible, replication would occur, what kind of stream disturbance would result from that, where, as I mentioned, replication would be absolutely required. That's a consideration and an additional cost to the applicant. So there are many, many other factors that cost estimate has not addressed.
Thank you. I'm going to deviate from my own rules for a moment, and I'm going to ask Mr. Wilkie if he wants to address us. Lloyd, do you want to say something? Okay, Lloyd is here with us. Well, hold on, Lloyd, hold on. Lloyd is here with his son, and I think they'd rather be home pretty soon, so why don't you come up, Lloyd, and...
Well, this is very short.
Come up, Lloyd, please.
I live at 92 Ford Ranch Road. I've lived there for 40 years. I just wanted to contest this gentleman's assessment of the stream. I've lived there 40 years, and occasionally it has gone off. One year it washed out my driveway. And it can go over the conduit with heavy rains. Whether that's a factor in the bridge or not, I don't know. Then, of course, the street is used by the whole neighborhood, walking dogs, running. It has a public kind of use that way. And of course, I don't know what effect it would have on the property values that you could sell your house for. So those are factors that are personal. Don't add to all the technical stuff which I don't know about. But those are just a personal influence. So that was short.
Thank you, Lloyd.
Thank you.
Greetings to your wife, Lloyd. Just for those who don't know, Mr. Wilkie lives next to the access on Ford Ranch Road that we're talking about. He lives to the left of it. Thank you, Bob. Now, yes, sir?
Hi, I'm Ed Renzel, I'm Lloyd's neighbor.
Okay, hey, Mr. Rentel.
Hi, how are you?
Good.
I drove Lloyd down with Stevie,
Okay,
and if you gave him the opportunity to speak, so we can probably get home early.
yep,
If I can have a few minutes.
sure, come on up. Yep. And Mr. Rentel lives to the,
I live
beside,
next house down.
Yeah.
I live at 174
Yep.
Ranch Road. There's a lot of this conversation has been about the houses.
so why don't you sit down if you don't mind?
Yeah.
Thank you.
There has been a lot of conversation about the houses at the top of Hillside Street and how they're being impacted by this development project. What it seems is that nobody is considering the three houses at the bottom of Ford Ranch Road. If you take a look at the plan, they want to pin a driveway or a road or a, what are the words I heard tonight?
12 feet.
I heard, let's see, a
Street
major
would be
driveway,
driveway, yeah.
a driveway, a road, I don't know, let's call it a superhighway too. I mean, basically, this proposed road that is here, comes down here, it's pinned right up against our two properties. Can anybody tell me the setback from our property line? The reason I asked, right, is that if you go down there and you checked out the elevation differences between our properties and the vacant wooded lots, there's a elevation height difference of anywhere between 5 and 8 feet right at our property lines. And as you get closer and closer to our homes, this proposed road here is actually at the height of our second-story bedroom windows. At Lloyd's house, it's at his rooftop. This proposed road or driveway, it's going to create a lot of flooding problems for us. Not only that, privacy issues. Basically, you're talking about lights coming down in the middle of the night, delivery trucks during the day, FedEx, UPS, mail trucks, garbage pickup, and directly right up against our property lines. You know, when we built our properties there, we built our houses there, one of the great things that we had is the fact that we had a pristine forest area behind our houses. And there's 3 neighbors that have been there a long time that are going to lose their privacy. And if you're planning on going forward with this, I think there has to be some consideration to us 3 neighbors at the bottom of Ford Ranch Road. I think a buffer of some sort, anywhere minimum 75, possibly 100 feet off of our property line with any driveway that's proposed, would probably make us feel a little better about the project. As it is now, like I said, there's an elevation change that may not be shown here. In fact, it's not. I see Bob Hannigan stop the elevations right at the property line. If Bob went over, he would see that the foundation of Lloyd's house and my house, the top of the foundation, would probably be somewhere 15, 18 feet below this driveway that they want to put in. And you're talking about a very steep area here. This is not flat. This is extremely steep, and it all pitches towards our backyards. So when we're going to have flooding issues, we're going to have flooding issues. We're going to have spring thaws. We're going to have major rainstorms. We're going to have major snowstorms. That water is going to go in only one direction. It's going to end up in our backyards. And what we would like to see, if anything, is a substantial buffer zone to absorb any of that erosion, runoff, water, privacy also.
Thank you. We'll take a walk up there someday, Mr. Vincenzo.
Well, you know, I tried to take a walk up there back in April, I believe, of this year, and I couldn't get the members of the planning board beyond the Jepson house because they were a little afraid of ticks.
Yeah, right.
And I wanted to show them the elevation changes and the steepness of this area where they're proposing to put in
Maybe if we came in for your
a
comment.
1,900-foot driveway, whatever it is, 1,750 feet. On Ford Ranch Road in a winter storm, you can't get up Ford Ranch Road. The grade is going to be much steeper for this proposed driveway going up that hill.
Thank you. And maybe we'll take a walk through your land into this porch that we're talking about.
Right, exactly right. I'd love it. I'd love it.
Okay, take care of these 2 fellows
All right.
for me, okay?
Thank you.
All right, thank you, Mr. Mantel. Okay, where are we?
You probably want more public hearing. I'm sure I have a question from Mr. Bobrowski before the end, but
Yeah.
it can happen after
Okay,
we've
it's
talked to
it's
everyone
10
else.
o'clock, we're not going to go much beyond 10:30, so I don't think there's any decision tonight. So we want to hear from, you want to ask some questions now?
I just wanted to ask Mr. Bobrowski a question, but I can wait till after the public has spoken. Oh, okay.
Okay.
Just for clarification, you had introduced yourself, obviously, and then Mr. Houston, and then you specifically called for Alex to come up. I just wanted to clarify whether Alex was a member
No.
of your team?
No, we
or-
had just talked just as individuals before, and he indicated he wanted to say something, and I asked him what, and then since the chairman invited me first, I wanted to just segue
Okay.
his thoughts in
I just
there.
wanted to make sure that was
And
clarified. Thank you.
not at all.
Okay, thank you. Is that it?
That's it, so.
Does anybody wish to come forward and talk? Okay, yes, sir, on the left, you were the first here this evening, so please identify yourself, your address. There's 2 of you. Okay. Team. Okay, it's getting late.
Yes,
We'll be quick.
we'll be quick.
Okay, thank you. What are your names, please?
Certainly. My name is Stephanie Foley. My husband here with me is Ken Foley. We live at 161 Hillside Street, and we are abutters to this property.
Ken Foley and,
Stephanie.
thank you.
The plan before us has been presented by Mrs. McKettrick, attorney for the developer. Mrs. McKettrick has dedicated many years of her time to this town. As a Milton selectman, she has been an articulate, faithful, and impressive public servant. However, this decision is about the development being presented and not the presenter. It is not a good plan. The plan is ill-conceived. It is quite clear by this proposal that the designers themselves have never had to endure the limitations of a long, single-lane shared driveway as we have for 60 years. Critical points have not been resolved at these public hearings. These new lots will all have covenants. With such encumbrances, they will be less marketable due to the expense of driveway maintenance, liabilities, and associated risks. 8 to 9 households will be using this Hillside Street curb opening for trash collection, recycling, mail, and newspaper delivery. These issues obviously all become greater hardships during the winter months. Comparisons to previously approved open space development plans, such as Stonebridge Lane and the Cox Hamilton parcel, are misleading. This is not a property planned solely for new development. Families currently live along this driveway, and for three families, it is their sole access. This poorly designed configuration has made no attempt to divert building activity from the current resident driveway space. It runs particularly into the Corliss and Jepson driveways. During the construction process, it will be like an occupation for the existing households. Unlike the Stonebridge Lane location, this parcel has frontage directly on a 40-foot, I guess we've discussed maybe 30-foot, town street with sidewalks.
The proposed length of this private, single-lane driveway is unprecedented. The town of Milton has never allowed a private driveway of this length, and for good reason, the safety of the residents. At 1/4 mile in length, the downslope facing north into the wetlands, the increased runoff will create treacherous conditions, especially in the winter. Milton has approved a lot of other private driveway developments, such as on Forest Street, which has 5 residences and is 525 feet long. Mail delivery and trash are at the driveway entrance. Unquity Road, which has 3 residences and is 650 feet long. It should be noted that although this is a driveway, each house has individual mail delivery and trash removal. The Highland Street Cox Hamilton property. This serves 1 residence at the current time and is 450 feet long. We have Bradley Road, which serves 6 residences and is 410 feet long. This development, being only 350 feet from the Atherton Firehouse, is probably our safest driveway development approval. None of these were over 650 feet. Stonebridge Lane, at 1,400 feet long, with no other development, no other street within 650 feet. Again, despite this being called a driveway development, all the mail and the trash pickup are at the individual driveway entrances. And then there are the hillside neighborhood roads, over 650 feet. We have Stonehill Lane, which has 6 residences off Hillside Street, 720 feet long, each house having individual services. The town required this to be a road for obvious safety reasons. Then we have Ford Ranch Road itself, at about 1,575 feet. Again, each of these has individual services. The proposed development area will have 8 or 9 residences, similar to Ford Ranch Road. Is single lane, and is, in many cases, we point out, almost longer than Ford Ranch Road. It abuts directly on the town road right here, and yet all the services for all of the residents will be at the single driveway entrances, right next to the Brezhnevan's house. Unquity Road, Forest Street, Bradley Road, Stonehill Lane, and even Ford Ranch Road were all construction that had no pre-existing residential use. In the case of Unquity Road parcel, the consideration for a separate driveway was certainly safer than attaching these 3 or 4 new units through Deerfield Drive. The construction equipment had to go directly through the existing residential neighborhood. We've talked about references to a bridge over Cooks Brook, and it's been quickly dismissed by the developer as, expensive, whatever like that. Mr. Houston made a wonderful presentation of a bridge. It it was fairly easy for myself, not an engineer, to use a few fingers on a phone, to talk to a few people, and find some things that companies that would provide residential private driveway bridges. The Excel Bridge Manufacturing Company provides an off-site built steel bridge with a span of up to 150 feet that can be dropped in place, minimal site or wetlands disruptions. As this is an example, this is an HS-20 bridge, suitable for a fire truck. That was a question that came up. This one's 35 feet long, 12 feet wide, and over the phone, the fellow was able to tell me that this bridge could be delivered on site. Delivered. $35,000 to $37,000. York Bridge Concepts provides a timber bridge. Nicer to drive over a timber bridge to your home? Timber bridge is built on site with the crew using overhead decking to preserve the wetlands. Again, they could build a bridge for HS-20, which is fire truck rated, 35 feet long, 14 feet wide, around $75,000. Pioneer Bridges. They told me they could provide a wide variety of styles, materials, built on-site or off-site, dropped in place with a crane, span lengths up to 200 feet, all at comparable pricing. Obviously, wooden bridges, steel bridges, there's a lot of options out there yet to be looked at.
Public hearings on this proposal began in September 2011 with the Milton Conservation Commission and continued in April 2012 with the Milton Planning Board here this evening. If you recall, people filled the hearing room on April 12th, and the following meeting on May 3rd, we moved to a larger room. Neighbors and abutters have followed these hearings throughout the summer. For an entire year, not a single person has supported the solution to the development of this land. Not a single person. We encourage this board to weigh other options that provide current residents and future homeowners with a safer alternative. Thank you very much.
Thank you, very well done.
I have some materials from the board. Some of the companies we looked
I
at.
was going to ask about catalogs.
Absolutely. Thank you.
Thank you.
Oh, very good. Thank you. Thank you for your assistance.
Thank you very much. Who else would like to come forward and say a few words? Just laid out. Nobody. Good.
That's not exactly encouraging.
Do I hear a motion to adjourn?
No, because you'd have to continue, if you're going to continue, you have to continue before we can adjourn.
Can we solicit the fire chief to attend the meeting?
You should talk. You should talk, go up there with him too.
Do you have any, well, I see Mary.
No, go ahead, keep going.
I'd just like to see if we get the fire
We
chief
should go up there.
to attend the next meeting, and just address some concerns.
That would be helpful.
I'd love to go up there too, go through Rentel's and, anyways.
Go in.
I'd like-
But you can't continue unless Marion wants you to.
Well, that's true too.
Mary, come forward, please.
Well, you've stated that you're not ready to make a decision tonight, so I'm not going to dispute that. And I guess you want to hear from the fire chief, but would you consider closing the public hearing and continuing to discuss, allowing for the fire chief to come in? Or maybe you can't do that, I guess. It's just that, it's not bothering me, but, every attorney has to get paid every time you have a hearing and they have to be here.
I remember Mr. Bobrowski making the same
So I'm
comment
just
at the last
wondering,
meeting.
obviously you need more time, but, what do you need the time for? So if there's any way you can try to limit that exposure for everybody, I guess that would be a courtesy.
Man, I hear two sides very well discussed and thought out and so forth. It's tough.
Yeah, so if you're not ready to do that, that was my only suggestion anyway. And also, before you close, if there are specific things that you want of the applicant, or if you could, I guess you could communicate that.
I'd like to, may I answer that, please? I haven't said too much tonight. I'd like to see Mr. Hannigan reconfigure lots 2 and 3, turn them 90 degrees, Bob. Put those two lots 90 degrees, they're facing up towards Hillside Street. And have a roundabout at the center of those two lots, a roundabout, and that would be the end of the so-called extra private drive. And you're going to have driveways to two houses which would be nearby, and the back land would flow off that way. You're going to eliminate a lot of roadway. Maybe, I just guessed, maybe 300 or 400 feet. There'd be much less, even if it came in a Ford Ranch Road, it would be an advantage to having a roundabout there. If you did come in off Ford Ranch Road. And you could also eliminate a lot of the hard feelings that I think will endure for years if this plan is adopted in its current shape. So make some considerations along those lines. Do you understand what I'm getting at?
I somewhat understand, but
It's a really, really interesting idea. I like it.
Someone understand the decision is my client. I'll have to discuss it with my client and see what his thoughts are. Now,
Even if you don't.
turn the lots, I don't understand how you can turn the lots 90 degrees.
To the right. Now they're facing up towards Hillside Street. Because of the wetlands, you have to make, the dividing line might have to be adjusted a little bit, not a...
No, I don't think that's, I don't think that's acceptable. Change the, you mean run the lot line this way?
No, straight.
No, 90 degrees. 90 degrees, and bring the houses up this way.
You have to figure out whether or not it meets the acreage requirements.
Yeah.
Oh, you still got the same acreage, well,
We're just talking about 2 and 3,
yes, ma'am, yeah.
not moving lot 1.
No, not this time.
They have to be 4 acres, so
I
that's the
understand, so
first
work on it,
problem.
Bob.
I don't think that's acceptable to the...
Work on it, see if you can do it.
Yeah, we've looked at numerous alternatives, lot configurations, and I think that these are the best overall.
I think
I'll
you can
discuss it with my client, but
Okay,
I
okay.
think this
you
is...
can make it work.
I think this
Hold
works.
up. Emily, go ahead.
Sort of following on from looking at alternatives, Bob, I'm looking at what Alex gave us with his red lines, which is actually a plan dated May 4th, 2011, and then what I have in front of me, which is the updated September 7th, 2012. And I'm noticing that there's actually a change in where the driveway terminates. Where in this one, in the May 2011, the driveway is actually terminating, and you probably have to come up here and see this. But I'm just wondering, well, 2 things. One, if it's possible to shift back to something like this that isn't running quite as close to the Ford Ranch Road properties in the May 2011. And the second is the question that Alex raised on where the driveway for Lot 2 comes off, so as to stop the major private driveway there. And wondering if you can address that either now or at a later meeting. So because the one dated March, well, updated as of September 7th, has the major private driveway going to the edge of Lot 3, but doesn't show where it might swing off Lot 2. And so that would be very useful to get.
So you would like us to show a concept for where the driveways would be going?
Yeah, exactly.
I mean, they've obviously considered.
Yeah,
for
well,
each lot.
we know that Lot 1, it's going to, it's going to come off somewhere midway probably. But Lot 2, I believe, as I understood what Alex was saying, is that the major private driveway would actually end where it turned off at Lot 2, and the remainder would just be the driveway to Lot 3.
The current proposal, the major private driveway ends here.
Yeah, but that what Alex, yes, I understand that's what you're saying, but I think what Alex said, and this is what I'd like you guys to clarify, is that the major private driveway would end where the driveway swung off to Lot 2, and from that point to Lot 3, it's simply a driveway.
Yeah, I mean.
And that will change the length
Yes.
of the road.
Yeah.
Okay, so then we need to know where,
Absolutely, yeah.
need to know where it swings off Lot 2. Okay, good, excellent.
Yeah, we can show you that. I
And
mean,
then the
originally,
other-
we were trying to treat the whole back part as just the driveway.
No,
But then
no, no, no.
upon reflection, it's the major driveway. But, yeah, at that point, once you've turned into Lot 2, it's then just a driveway to the
Lot
third
3.
lot, I guess.
So knowing where that would be is, and then what about where it is in relation to the Ford Ranch Road properties, those last two, the Wilkies and the rentals? Is there any other way? Because this one, the one dated May 4th, it seems to swing further away from their property. And it'd be, and I haven't used a scale to double check that, but it'd be interesting to know if it's possible to shift it a little bit further
I mean, you
away.
understand the point that may I speak? I'm
Yes,
sorry.
of course.
The point that I made earlier was that if you try to move it entirely over
Yes.
or to the middle, you're just moving houses over to the, and you have a worse problem than you do with the driveway. However, the question to go back to Mr. Hamilton is, can you move it over at all?
Yes.
Any-
Yeah, I'm not
any
asking you to move it to
increase
the
of
other
distance
side
is-
or the middle.
is helpful,
Yeah.
and we are aware of the topography at that point. We've all
Right.
walked a bunch of times, and it definitely goes down towards those houses, so.
Yeah.
I don't know. I guess we'd want to take that question back and at least ask it.
And
Just have a look.
Yeah, and a 10,000 square foot building envelope is totally unacceptable. The
Yeah.
Building envelopes are outlined in green.
Mhm.
When you have an expensive piece of property, then the buyer wants maximum flexibility as to where they want to site their home,
Right.
and that's it. 10,000 square feet
And
is.
I mean, I didn't respond to that either, but a building envelope is all the possible areas where the house could be. It's not that the house is going to be that big. And I mean, I think Mr. Whiteside understands that. And this shows you, you know,
Right.
where it could be with with the required setbacks. And it's not going to be everywhere, you know, I guess. If there's some, I mean, I think the Conservation Commission is going to need to see where buildings would be located, because they have all kinds of conditions that apply to drainage. And drainage, by the way, the issues that were discussed for the roadway, those are all issues for the Conservation Commission, and they were significant issues that the Conservation Commission will be dealing with and the applicant will be dealing with, because there isn't supposed to be runoff into the wetlands down below and back of this area. And it is an upland, and there are all
Right.
kinds of areas that go
Understood.
downhill. So that definitely will have to be dealt with.
Bob, I'd like to point out that if you do configure the way I was asking, take a look at it, you have an acre. You could take from lot 1 and use on 2 and 3 to bring the houses up.
I'll look at it. but I-
Okay,
I'll look at it.
it'll work, make it work.
And just a couple of notes on drainage. Stonebridge Lane, there was minimal drainage on that, and that's the concept here. Minimal amount of pavement, minimal amount of drainage, flowing naturally off the paved road. Really, the only drainage that was provided at Stonebridge Lane was in the area where the bridge was adjacent to the vernal pools. It was collected, it was treated in storm scepters, and then discharged underground into some leaching. So the concept is generally to keep it as minimal as possible. And one thing that's really bothered me since perhaps the last meeting or meeting before, and I'd maybe like an explanation as to what's the difference between Stonebridge Lane approval and an approval of this particular proposal? How a member of the planning board could approve Stonebridge Lane, length of driveway, and now strenuously object to this proposal, which is very similar in nature, in length. That's bothered me.
I'm not sure
That's a
that we...
rhetorical question.
Yeah, I'm not sure that we interrogate the planning board. It usually works the other way around. I think the point I've tried to make is simply that the history of planning board decisions is part of how we understand bylaw. We also have to look at, you know, when it was enacted and we have to look at the plain language of the bylaw. But that's all. We've had a lot of discussion of that. And the history, it's not that you can't deviate from a decision you've made before, but it helps understand how the bylaw's been interpreted and what sorts of things have been applied to this issue, for example, of roadway length. The fact that there is a development permitted that has, and I thought it was a 2,000-foot roadway length, someone said 1,600 feet, but in any case, that you've permitted one is indicative that, you know, it's possible to do this, and in fact, it's been there, and as far as I know, there haven't been any problems, but it's not, if it were illegal from some other standpoint, I suppose, the fact that you've done it in the past doesn't mean that you continue to do it, obviously. I know you've sought some advice from town council, so I think, you have that now. But I understand that you do have some questions that you want us to give you some answers on. And we will come back and we'll go back to the developer and we will see what kind of feedback we can provide for you at the next hearing. And if you could just give us some idea when that might be. Is that going to be the 27th or?
Good question. What do we have on the 27th? I know we scheduled quite a bit.
That's what close, isn't it?
Yeah, it's next week. Does that give you enough time?
Well, let's see. What kinds of things?
It'll
Yeah.
depend upon the applicant. so.
Are we close to a decision on this? Yeah, might-
You were the one who said we didn't want to make a decision tonight.
I thought we could, but the more we talk about it, the more elusive it gets.
I don't know why we can't get an answer on,
Any
think,
advice, Paul?
Make a decision.
but redrawn plans,
I'll make a decision when the decision needs to be made. It's not my decision.
We would have to.
Yeah, I mean, we're willing to come back on the 27th with everything that we can bring at that time, and if we're unable to complete something, we'll have to report back to you that we need more time to do that part, but we'll do our very best to get the answers.
I just want to pose a few theoretical situations if I could. It seems to me that the way to go about it is off of Ford Ranch Road, but there's all complications, I understand that. If that were possible, I think you'd have good neighbors, new neighbors, and good old neighbors working together, because things would abut. It could be pedestrian walkways all the way through the hillside streets, emergency access if needed, better plowing, which would assist the existing homes, better plowing, and an alternate way to go in and go out if there's 2 feet of snow and so forth and so on. At the same time, if we have these 3 houses back there, and they decide, let's have a big party, okay? Now it's,
like that one we had recently.
now I'm not even that big, but now it's 10, 11 o'clock at night, right? And it's time to go home. And sometimes it's noisy when people are leaving, and it can be dangerous and so forth. So that would be an advantage to use Ford Ranch Road, but now the Ford Ranch Road people at the same time wouldn't want it. But we have to try to find how we're going to do this. And I don't think we made much progress tonight. I think it went this way tonight, not that way. And I don't know if that was my fault or what, but if we have to try to come together and decide it without too much rhetoric and so forth. Just get it done. So let's work on that together, okay? So here, motion to adjourn.
No, we have to continue it
Oh, yes, well,
to a specific date and time.
yeah, what is that date and time? I think
What do
next
we
week
have
is
open on the 27th? Do you remember the times that we locked in?
Don't.
Yeah, I don't have my notes from the last meeting.
I do. We have the landscape at 6:45.
Yeah.
We have the Bosworth at 7:15.
Is that it?
That's it.
We didn't do 36 to 50?
No,
We didn't do 3650 Elliott
I'm not sure. Okay.
that same night?
They're coming
Or are they coming-
October 11th.
Oh, that's right, they're coming October 11th, so 7:15, so we could conceivably do it 7:45?
Yep.
All right.
Mr. Chairman, I'm Berkeley Town Council, and I have an engagement in Berkeley that evening. I think their meeting will start at 6:30. Don't expect to be there beyond 7:45.
Where's Berkeley?
Berkeley's down 24, just
Way out
after Taunton.
Way out there.
How long would it take you to get back?
At the rate I travel, 35 minutes.
So would you like,
Although those new police patrols are.
Cramp the style.
so you would like to go 3 weeks out to the 11th?
I can come on the 27th, the 11th is wide open, so.
Pardon me?
The 11th?
I can come late on the 27th, but the 11th is wide open.
It's open for you. Oh, let's try to, yeah, let's do the 11th and see if we can talk.
Don't ask me, you have to ask the
Yeah.
proponent.
No, you don't, because it's not,
We'll talk
This is
about,
the continuing.
We're
of the
trying to
hearing.
be fair to all
Do they wanna
parties.
there's no
continue it.
extension necessary.
Right.
Yes.
Marion, the 11th, okay, October?
Yeah, well, I'm available on the 11th, and are you, Mr.
All right,
Hannigan?
Mr. Chairman, could I just ask one question?
Go ahead.
What are we expected to see when we come back here 2 weeks hence?
I don't know.
So should we give them some direction?
Go ahead.
We're going to vote on this, and because, you know,
As I
we
said,
do this all the time, we keep coming back and back and back.
We could,
It would be nice to see the applicants investigate the possibility of coming off Ford Ranch Road further with cost analysis and maybe some input from the Conservation Commission.
Then we're gonna have the Ford Ranch Road people up here. I understand. But it's a valid question, it's a valid point.
You never make everybody happy.
there's a couple of different ways we could do it. We could either do what we're doing now, which is simply continue the hearing and ask for various questions that have been raised tonight to be answered. We could close the public hearing and ask for the information to come back to us at the next time. The public wouldn't be able to speak, but we could, well, you know, I'm just outlining the possibilities. We could call it for a vote tonight, and then vote, however we're going to vote. We could make it subject to certain things being clarified. For example, we have this, this document here that, you know, we have copies for people with the easement and covenant, so we could vote. If it's a vote to deny, obviously it's over. If it's a vote in favor, then we could make that subject to some of these items being clarified. That's probably the most complex, having a vote and then clarifying things afterwards. So I'd say the best possibilities for tonight are either to simply continue it and continue the public hearing and have some of the questions answered, or to close the public hearing and have some of the questions answered, but then it would be a shorter meeting, potentially a shorter meeting, if the public weren't allowed to speak. If we close the public hearing, we would have to decide, obviously, we would be asking the applicant to come back and give us further information, so they would be speaking. We'd have to decide whether or not to give opposing counsel the same right to respond to any information that came in. So
The applicant agreed to consider Ford Ranch Road.
the applicant has not necessarily agreed to do that. I think the...
They don't agree.
Right, exactly. It's their choice as to whether or not they wish to submit that information to us. They may choose not to. So, in which case...
I'm one member, but...
Yeah, I think what you, excuse me,
I would
but,
not vote for this plan as it is written now. I want to see different dimensions on the width of the road. I want to see streetlights. There's a lot of safety issues.
Okay. So then we probably shouldn't have a vote tonight because you're not satisfied with the
but
dimensions.
could we have the benefit of what you would be asking for so that we could try to address that, or are you not sure at
Yes,
this point?
I was involved with the Woodland Road situation, but in my life, something has come about. A wife that 12 times has gone to the emergency room. And I could not envision us living here. She would be in a cemetery now. The road is just not safe. And I know most of the neighbors here. I love nature too. And a lot of the decisions we're making is because someone doesn't want a shrub cut down, and I don't blame them. But it's the safety of the road. And I've lived it for a year, and I just would not want to see us approve the 12-foot road, although some people are talking now about 14 or 15 feet. I would like it 20 feet. I need streetlights. I know the streetlights are going to really make the neighbors upset, but it's safety. And 8 or 9, 1,800 feet, 1,700 and something feet of road. And just as Ed mentioned, if they had a party up there, oh God, that would, coming down on a 12-foot road, and so.
I mean, that's true on the end of the 900-foot driveway, but I haven't heard of there being any big parties up there, and I doubt that there will be.
Well, there was right next door.
But, there's always the extreme example, but the public safety issue is certainly very...
Yeah, and it's really, and I've lived it, and I don't want other people to have to live it. And it's our responsibility to try to come up with a safe road.
On the lighting issue, regardless of where access is coming in from, one solution that has been found, which I've already mentioned, is that lighting can be provided at each driveway, and the driveways are interspersed, they're at intervals, so that it provides additional lighting, and I know this is in other developments in other places, this has been done, so that they look like lights that go with the house, and
Have you
they
ever
illuminate.
driven up 1,800-foot road at night with no lights and just house lights.
Well,
And
this
especially if you're not
these are
familiar.
lights. They're kind of
Especially
made
if
to
you're
look
not
like
familiar with
they
the
belong to
road.
the houses, that's all I'm saying. I don't know much about it, but I have seen that type of lighting, and it helps.
and this has a few closing words.
Should we, before that, should we just, Bernie, should we say that we're looking for an 18-foot minimum?
At least.
Well, we were willing to approve Brush Hill Road at 16 feet with lights at the bottom of each driveway.
Well, what's the
So
length of that?
I do not remember off the top of my head.
Probably not
what it
16,
was.
50.
And they're coming back on that October 11th.
Oh, are they really? Well, that'd be quite a conversation. So, I do have a couple of things that I would add if the board were to approve this project. I would have an arborist on site during construction, during the portion of creating the driveway near those trees, so that the arborist is on site while the hard-packed road is being cut out and while everything is being put in and making sure the trees are properly cared for. And that should actually be added to the construction management plan, anything that the arborist says to protect the trees. Again, this is if the board were to approve this.
Mhm.
I would also put time limits for completion on it as allowed under section 6N. I don't know what the standard is, but maybe something like 3 years, so that if this were not done in 3 years, rather than having it languish as the Flatley one was. I think also we need to note that there would be a requirement to come back before the land, so that the land was divided, whether it was under chapter 41. Whether it was an A&R or a subdivision control. As you've had an attorney mention each, but you know, this is subdivided, so whether it's an A&R as in past practice, this does not subdivide the land, this is a special permit. So in past practice, it's been an A&R. If it has to be subdivision control, that's another thing, but this is just the open space permit. It doesn't divide the land.
So you would want us to request, we would be, well, if it were this development, we'd be requesting A&R.
Right, exactly.
And our
But we should just
contention is
know-
that it would then be able to get an A&R.
Right.
Yes, I understand that. I
But
know
it
you
should have
haven't-
in the conditions that that still hasn't yet been done.
Right, or, okay, or we could just be requesting it, but, I mean,
Well,
it
we
should
don't
be,
have the
it
request
could,
in front of us now, so, for the A&R, that hasn't been.
well, it's
filed.
only because you haven't asked for it in any of these other permits.
Which is fair enough, but just as I'm looking at the conditions,
Fine,
the
whatever.
subdivision of the land is not here. So,
Yes.
and let me just double check, make sure I'm not missing anything. Lights the end of the driveway, arborist, yeah, okay, I think that's good.
I would just like to add that I regard the 12 feet as excessively small. We have to go larger than 12.
You know, we came in with, we had a 20-foot wide driveway in our original plan. We talked to neighbors, they were worried about the changes, so we went as far as we felt we possibly could in the other direction. I had expected from day one, we'd be discussing the width of the driveway with
16
this
or
board.
18, yeah.
So I'm not in the least surprised to hear
Okay.
you talking about it, and I'm happy to hear you considering it carefully. We can,
It wouldn't hurt, too.
you know, we can deal with that. I think there's other difficult issues as well that you're struggling with.
Yeah, but also, you know, we're not making progress very quickly, but perhaps the attorneys could sit down and talk to each other too, with the developers. You don't need any special laws and rules and regulations to do that. Maybe we can get somewhere doing that.
Absolutely, and I know each attorney has expressed the willingness to do that.
Okay.
I've expressed the willingness to do that. I haven't really had or been sure what it is that we could talk about. I don't know even now whether there's a lot of give. I mean, it may be, this is the applicant's decision, you know. But I would say that I think the question you want us to go back with, in addition to everything else, is would this applicant consider trying to use Ford Ranch Road access for a 3-lot open space development permit? Is that correct?
Yeah.
And then that this board, I'm not telling you what the answer is going to be, we'll go and ask though, but that's the question, right? You can't go beyond that, and you seem to feel that you have the scope to allow that discussion within this application, or not?
No,
It would have to be a new
We don't have
application,
that scope.
wouldn't
it's a
it?
different plan.
They'd have to submit a
Yeah.
different plan, but we could allow the
Yeah,
discussion
we can
under the
talk
current
about it.
application.
Okay, well, anyway, yeah, we will.
Mary, when are we meeting again?
So it'll be the 11th, is that what you said?
The
That's-
11th,
7:15.
7:15.
Is that okay with Mr. Bobrowski?
It is, Mr. Chairman, thank you. May I
Okay.
pose a question?
Yes, sir.
I give it to the board as well as to the applicant. How is this better than a defensible denial? I'd like to know the answer to that question.
I don't know the answer.
Well, the only thing I've heard referenced is that everyone has the right to use their land. They've got one building lot back there. That's not a taking in any way, shape, or form. That building lot is worth maybe 6 figures. So why does it have to be 3? That's my question.
We may have the right for 2 A&R lots. We have enough frontage for 2 A&R lots.
You can't take another off of the private driveway.
Exactly, it poses the same questions as this one does, and the same answers.
You can-
If
you can buy a house
DEP
on
says that
Ford
we...
Ranch someday and put in an orthodox subdivision, I'll give you that, but not for sale. And there are only 2 candidates. Maybe 3.
Well, okay,
Okay,
I don't think we need to, I understand your contention, and
is there a motion to adjourn?
I think you agree that it can't be
Continued.
not used at all.
So we
One
can,
position,
Yes.
someone's ready to...
they'd agree to continue.
Is that one, Bill? Bill?
I will move,
Kevin-
Mr. Chairman, that we adjourn.
We have adjourned, thank you.